And we are recording.
Great. Let's call to order the Sunshine Ordinance Task Force meeting of February 3rd, 4:05 p.m. Please call the roll.
Member Schmidt?
Present.
Member Schmidt present. Member LaHood?
Present.
Member LaHood present. Member Frazier?
Present.
Member Frazier present. Member Padmanabhan, I hope I said that right. Member Padmanabhan?
Present.
Gaia? Oh,
Yeah.
present. Okay, great. Member Wong? Member Wong? All right, we'll check in later. Member Stein?
Here.
Member Stein present. Member Yankee?
Present.
Member Yankee present. Member Highland?
Present.
Member Highland present. Member Jones Neighbors?
Present.
Member Jones Neighbors present. Member Forsley?
Present.
Member Forsley present. Chair Wolf?
Present.
Chair Wolf present. We have a quorum.
Okay, great. Okay, let's start with the opening statements.
Okay. Remote access to information and participation. In accordance with Governor Newsom's executive order and declaring state of emergency during the COVID-19 outbreak, and Mayor London M. Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer. Aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Chair Wolf, at this time, I'm not aware of any agenda changes unless somebody else has them.
All right, let me just iterate the meeting decorum. Any
Pardon
member
me, can
of
you
the
all hear
Sunshine...
me?
Hello?
Hi, this is Jen. This is Member Wong.
Yes, we can hear you now.
I didn't get an email about the Teams invites. I was wondering if someone could send that over to me, please.
Yes, we can do that.
Thanks. Apologies for interrupting.
Okay. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Okay. Let's call not item number 1.
Call to order, roll call, and agenda changes.
Okay.
I am unaware of any agenda changes. Do you know of any, Chair Wolf?
I don't. Any adjustments or changes to the agenda? Okay, seeing none. The only thing I will just iterate that after public comment, not after public comment, after item number 6, we will take a 10-minute break, a 10-minute recess, get everybody oriented and whatever folks need to deal with personal things. Okay, let's start with the first item.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force December 21, 2020, orientation, and January 6, 2021 meeting, and January 12 special meeting.
Okay.
I have copies of the minutes. If anybody wants to suggest changes, I'm happy to do that.
Okay. Let's take them one at a time, since there's so many of them here. Are there any changes or adjustments to the minutes of December 21st, 2020?
I have one. This is
Matthew?
Yes.
Member Yankee?
Yeah.
At the bottom of page 3 or P3, it says second to the last line says voting seat. It should be non-voting seat.
Wait a second. Second to the last line, voting seat. At the bottom of item number 4,
That's correct.
non-voting seat, a non-voting seat.
You see it, Cheryl?
Yeah,
Okay.
I'm writing it in right now.
Okay, great. Thanks. That was all I had for that one, although I have more for
For
that.
the orientation.
For that, yes, that's correct.
Anybody else?
Any other changes or adjustments to the minutes of December 21st? Okay, hearing none. Let's open it up for public comment. Any public comment on the minutes for December 21st?
Yes, anonymous.
Okay, Cheryl?
Just a second. Go ahead, sir. Go ahead, anonymous.
Oh, okay. Which one of us is speaking?
Anonymous.
Okay. So on page P5, which is page 4, it says, that's me, anonymous, said 3 things. When it says anonymous stated that on November 30th, Hank Heckel and David Steinberg discussed with him, it should say disclosed to him that there may be an appointment to the mayor's non-voting seat. I did not say they discussed. They disclosed that in the public record. Thank you.
Hang on a second. What are you talking about? What item number?
All right. That is P5, which is
No.
page 4 of the...
All right, page 4.
Okay, halfway down the page, it says public comment, anonymous, etc., etc. The word discussed with him should say disclosed to him that there may be an appointment to the mayor's non-voting seat. Thank you.
Okay, anonymous. I don't have a copy of the minutes as provided in the agenda packet. So if you could look at the bottom right-hand corner and tell me what page it is.
Sure, it's page 4 is the bottom right-hand corner. It says under section 11, public comment.
Under section 11, public comment. Chair Wolf noted that this section deals with public comment.
Yeah, and then there is my public comment underneath that. And the
Yeah.
sentence that needs to be corrected is anonymous stated that on November 30th, Hank Heckel and David Steinberg discussed with him that there may be an appointment. The correct, what I said was Hank Heckel and David Steinberg disclosed to him, as in me, that there may be an appointment to the mayor's non-voting seat. They haven't discussed anything with me. They disclosed the public record. Thank you.
All right, great. Thank you for that comment.
Next speaker?
Is that me?
Go ahead,
Mr.
speak.
Warfield? One moment, sir.
Did you say one moment?
Yes, I did. Do you have a comment on the changes?
I have a comment on the minutes, on the discussion. I would very much appreciate if you would consider that those of us who don't recognize voices and are on telephones, and especially with possibly new people, that you please identify each speaker and also what pages specifically and so on, as you just did on this item. But when you're talking amongst yourselves, that you please reference specific pages so that folks can follow along if they have a copy in front of them.
Okay. So you have public comment. So you have 3 minutes, sir.
That's fine. I'm Executive Director of Library Users Association, and we can be reached at libraryusers2004@yahoo.com. Also, P.O. Box 170544, San Francisco, California, 94117-0544. That concludes my public comment. Thank you.
Any other public comment?
Sullivan.
Go ahead, sir.
Go ahead, speaker.
Okay, can you hear me?
Yes, we can hear you fine.
Okay. I'm happy wait a second. Speaking to the discussion of attorney-client privilege on January 12th meeting, official information privilege allows a public official or public agency or task force such as yourself to withhold information submitted to them in confidence until and unless it has been expressly relied upon in making a decision. If the public interest in such secrecy outweighs the public interest in disclosure. San Gabriel Valley Tribune versus Superior Court, 1983.
I'm sorry, Speaker, I'm sorry to interrupt you. Is this in reference to the minutes of December?
Oh, I thought this was public comment. I'm sorry, I just got on.
Oh, it's public comment for the minutes.
Okay, I'm sorry.
Okay,
Oh,
we'll have public comment around 5 o'clock. So
okay.
we'll start afresh again then. Okay, last call for public comment on the minutes. Hearing none, please call the roll.
We didn't have a motion. And are we going to look at the rest of the minutes?
We need a motion, right. Sorry. Is there a motion to approve the minutes? December
Sure,
21st.
I move to approve the first set of minutes from, I forget what date that was, December
21st.
21st, with the changes that were referenced in public comment and what I gave.
I second.
So moved by Vice Chair Yankee, second by Member LaHood. Ready for a vote? Okay. Well, please call roll.
Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Did anybody send her the, all right, go ahead, finish the roll.
I heard aye. Jennifer? Member Wong?
Aye. Yeah.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to adjust the minutes as per the request has passed for December 21, 2020.
Okay, great. Next set of minutes, January 6th, 2021. Any changes or adjustments to the minutes? Okay, let's open it up for public comment. Any changes or adjustments to the minutes of January 6th, 2021?
Yes, anonymous, please.
Go ahead, Anonymous.
Thank you. As was requested in a prior committee when me or someone else had numerous corrections to suggest, I have submitted a written list of suggested corrections here, both for my own cases, other people's cases, and what the government said. And the reason it's important is because what is recorded in these minutes, I understand, gets copied into your order of determination, which constitutes the administrative record if someone has to go to court. For example, in some of these cases, it's the discussion from a different case has somehow gotten into a different file number. So I don't know if I sent those to Ms. Leger a while back. I don't know if those corrections are being explicitly rejected or if they just haven't been considered. I'm happy to read all of them into the record, but I thought by submitting it by email would be more efficient. They do make a material impact to what is in these cases. I'm happy to go into more detail if the task force would like, but I have submitted them by email. Thank you.
Any further public comment?
Yes, please.
Go ahead, sir.
Is that me? Yes,
sir.
This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com. Also at P.O. Box 170544, San Francisco, California 94117. I think that Anonymous has made a good suggestion, but I certainly think that since it's a public meeting and public actions are being taken, that there be some discussion openly or some visibility for suggested changes. I don't think this would be difficult because you presumably have your draft minutes within 10 days posted, or not posted, but available anyway on request, and perhaps posting them would be useful. In that case, you could, if you wanted to, add those to the agenda, excuse me, so that everybody could have advance notice of what is being proposed. I do think that minutes are important, and have always appreciated when you have made efforts to have full minutes about what happened both within your discussions and with regard to the public. I also hope that folks have heard me. I don't know if there's a problem with identifying people. I think that it would be useful, as I say, to identify the speakers for those who are on the phone and can't see. Presumably you guys can see who is speaking, who is making motions and so on. You do announce during motions, for example, but it would be very helpful for the public to follow, to hear who is speaking or who has been recognized. And yes, I think minutes requests for changes should be seriously considered, and the corrections made publicly so that folks can understand what changes were or were not accepted or made. Thanks very much.
Next speaker. Any other public comment? Last call for public comment. Okay, seeing none, members, is there a motion?
I have a question. Since we haven't seen the proposed changes, I don't know, or I haven't seen the proposed changes. I don't know that we can vote to approve it this time unless others disagree.
We can move to continue the item. So the changes that are being presented could be considered. I mean, they're being presented by a member of the public, so it's a suggestion or a request for us to consider them. If we haven't seen them, then, and you would like to have an opportunity to do that before approving these minutes, then I would suggest that we continue the item to the next meeting.
Okay, then I'll make a motion to continue the item until the next meeting so that we have a chance to look at the suggested changes and determine whether we think they are appropriate.
Okay, it's moved by Member LaHood. Is there a second?
I'll second that.
Seconded by Vice Chair Yankee. I would just as a chair prerogative just request that our administrator please forward that submission from the anonymous public commenter to all the task force members and anybody else who requested. Okay, let's take public comment on the motion to continue. Is there any public comment on the motion to continue? Hearing none, are we ready for a vote? Please call the roll.
Member LaHood?
Aye.
Member LaHood, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Fraser?
Aye.
Member Fraser, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to continue to the next task force meeting and to forward the suggested changes by anonymous passes.
Okay, thank you. Then the last set of minutes is for January 12th, 2021. It was a special meeting. Any changes or adjustments to that set of minutes?
I have one small one. This is Vice Chair Yankee. Cheryl, on item number 4, under announcements, comments, questions, etc., you used to have note actions. I'm assuming you meant no action.
No action.
So,
Yeah, I'm sure that's what I meant. Let me just get to where it is you're talking about. Number 4, January 12th. Yep, got it.
okay, that was all I had. Thank you.
Members, any other changes or adjustments to the minutes? Okay, let's open up for public comment. Changes and adjustments to the minutes.
This is anonymous, please. Hello?
Just a second, sir.
Oh, sorry.
Go ahead, sir.
Thank you. This is regarding page 2, item 2, public comment number 2 on P20. The last sentence of my public comment says, Anonymous emphasized that he is really considering public interest and urged the SOTF to disclose and release the communication. The first half of that should say, Anonymous emphasized that the SOTF should not consider the public interest balancing test. I was disagreeing with Mr. Pilpel's earlier comment. So the first half should say Anonymous emphasized that the SOTF should not consider the public interest balancing test. And the rest of the sentence is correct. Thank you.
All right. This is for the January 12th minutes.
Yes.
I'm trying to find where it is he's talking about.
Would you
This
like
isn't-
me to?
Is this under general public comment?
No, it's item 2. This is where you waived attorney-client privilege for the records request I made. It says public comment, and then there are 2 public comments, one from Mr. Pilpel,
Pilpel and one for you.
one for me. And I'm saying that the first half of the 4th sentence under my comment, where it says Anonymous emphasized that he is really considering public interest, it should say Anonymous emphasized that the SOTF should not consider the public interest balancing test. And then the rest of it's correct, and urge the SOTF to disclose and release the communication.
The SOF should not what? I'm sorry, sir.
Here, I'll say it again. Anonymous emphasized that the SOTF should not consider the public interest balancing test, the exemption under 60 under the CPRA, and urge the SOTF to disclose and release the communication.
Okay.
Okay, any other public comment on the minutes, changes or
Yes,
adjustments?
please.
Cheryl?
I'm with you. Just a second. Go ahead, Mr. Warfield.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com. Also at P.O. Box 170544, San Francisco, California, 94117-0544. Assuming that Anonymous did in fact say what he said, and I have no reason to doubt it, I don't think that any or many of you would. This is a very important thing, and for whoever whispered, oh gosh, God, or whatever, this is important. This is a major difference between the Sunshine Ordinance and the Public Records Act. And that is that the Sunshine Ordinance specifically says that the balancing act, the balancing consideration that the Public Records Act allows is disallowed under Sunshine. And as far as I'm concerned, as somebody who's had many years of experience with filing many complaints and winning most of them, as others have done in the past and colleagues and so on, that's important because that doesn't allow the agency who has the material basically to argue that the public interest, some broader public interest or another, allows them or requires them to withhold documents. So this is not an annoyance or a trivial thing. This is an important point that was being made and that needs to be understood by everybody who is dealing with Sunshine. The agency can't just come up with some balancing argument and say, well, the public interest exceeds the interest of the requester, and therefore we can deny or should deny access to the material. So this is an important point that needs to be gotten right, especially since this is the Sunshine Task Force.
30 seconds, sir.
And that's all I have to say. Again, I would appreciate if people would identify themselves or if the chair would identify who is speaking so that the folks on the phone can hear and understand who is making the speech. Thank you very much.
Any other public comment on the minutes? Hearing no public comment. Member Wong.
Sorry, not a comment on the minutes. This is Member Wong. Cheryl, do you mind muting yourself and all of the people who are calling in, please? We're hearing some of the background noise from that.
We'll take care of that after we get to the vote. After we get to the vote, because we're right in the middle of the process here. Let's finish the process, and then we'll deal with the personal privilege points. Thank you. Okay, any other public comment? Hearing no public comment, members, any last thoughts on these minutes? Hearing none, are we ready for a vote?
We need a motion.
Oh, we need a motion. We need a motion.
So I'll go ahead and move to approve with the requested changes.
I second, and this is Member Frazier.
Okay, thank you. So moved by Vice Chair Yankee, second by Member Frazier. Are we ready for now, or are we ready for a vote? Okay, great. Please call the roll.
Member Yankee?
Aye.
Member Yankee, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood?
Aye.
Member LaHood, aye. Member
Aye.
Member Highland, aye. Member Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the minutes with the requested changes passes.
Okay. We're just going to take a point of privilege here to ask everyone to please mute themselves. If you're on the phone, it's *6. Would appreciate if you could self-facilitate that because there's always a lot of background noise or inadvertent talk that could be disruptive to the meeting. Would appreciate that. And Victor, you can go ahead and mute everyone, and then everyone now has that instruction. Okay, great. I would also ask that all the task force members, we can see each other. I'd appreciate that you leave your cameras on, because if we were in a meeting and you were not in the room, then you would be not counted as quorum. So having your cameras on tells me that, and the clerk, that we actually have.
Lost audio.
My apologies. I was muting. I didn't notice I was muting yours, Chair Wolf.
That's okay. No problem. So thank you, everybody, for doing that. Appreciate it. And keeping yourselves muted keeps also the background noise. Things get haphazard doing things remotely. We just want to try to keep things running smoothly. Okay, great. Let's move on to our next item.
Item number 3, hearing to consider action to close Sunshine Ordinance Task Force complaints due to inactivity and other violations of the Task Force complaint procedure for file numbers 19115 and 19126. Shall I read the complaints?
Yes, go ahead, please.
File number 19115, complaint filed by Ann Trabeau against Margaret Baumgartner for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request for public records in a timely and or complete manner. File number 19126, complaint filed by Ann Trabeau against the San Francisco Arts Commission for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and or complete manner.
Okay,
so I'm going to mute myself so I can hear everyone.
Okay, and can you please explain the reason why we are closing these from the administrator's perspective?
From my perspective, I actually got two emails from Ms. Trabeau, and one of them was, I believe, in late January. She said she wanted to continue her matters to after March, and then in March she wasn't available for a hearing, and at that point I think the task force had ceased meetings, and then she emailed me and said she wanted her complaint to be heard after May 1, and then I didn't hear anything. So
no, that's not what took place.
Ma'am, can you wait until I'll call on for you after the clerk has her time to finish explaining? Thank you. Go ahead, continue, please.
And the truth is, I've gotten no request for any kind of action. So
okay. Thank
that's
you.
where we stand.
So, Ms. Trabeau, can you wait until I recognize you? The task force has the opportunity to discuss this, and we have a lot of new members that may have questions. So I'll give you an opportunity to speak, and that's why we contacted you. Thank you. Okay, members, are any questions or discussion on this? Member LaHood.
Yes. If we could be reminded when these were initially filed, how old are these cases?
They are from 2019, as indicated by the number.
Right.
And they are late in that year. The actual date of when these cases were filed, if you hang on a second, I can check my chart.
That's okay. Thank you. 2019. That's good enough. Thank you.
Any other questions, members? Vice Chair Yankee, go ahead.
Cheryl, did these go to committee at all?
No.
They were heard or were not heard by committee?
They were not heard by committee.
Okay, and they were asked not to be heard by committee, or was it scheduled and the...
It has been scheduled, and she, like, again, I'd have to check my chart. I can't remember off the top of my head. Do you want to give me a minute?
Sure, that's fine. I was just wondering if this was like a no-show type of instance.
No, it wasn't that. It wasn't that at all. It was non-communication, and you know, she made requests to have her cases heard after twice, saying that she wanted her cases heard after March 1st and then after May 1st, and then I didn't hear from her.
Okay, thank you, Cheryl.
Okay, anybody else before I allow the complainant to have some time? Okay, let's do that. Ms. Trabeau, I'll give you 5 minutes to say your piece on this, and then task force will discuss how to dispense with these 2 cases at that time.
Dispense. Wow. Ann Trabeau, United States Open Government. Ms. Leger, in the many conversations I've had with her from 2019 up until this morning, phone conversations, there was no mention that these complaints were going to be tabled or going to be moved in any shape or form. She hasn't provided any evidence of her allegations in this agendized item today. And when in my many conversations with her, she says, Chair Wolf told me that they are going to be closed because you haven't contacted us. So I spent the past 2 days reviewing the Good Government Guide, the Sunshine Task Force, the Sunshine Ordinance, the Brown Act, the California Public Records Act, and nowhere in these things is there any mention that you have to call in every 2 weeks to say, hi, I'm here, I'm available. These cases are from 2019. The burden nowhere in any of these things does it say the complainant has to call in to follow up, to say, hi, what's going on with these complaints? That's what Cheryl told me this hearing is about today. I actually rushed to get a response in to both these complaints before the 3-day deadline, and I was under the impression that there were going to be hearings today. So once again, Ms. Leger has misled me. She hasn't provided any evidence to support her claims. I can tell you for a fact that I have been calling. She doesn't even know if I have any additional complaints in the queue. So I suggest that her recounting of what took place to be completely false. I was not notified of any hearing except for the one today.
Does that conclude your statement?
Well, what she's alleging is that I have not communicated with the Sunshine Administrator. That is not true. I've done it by email and by phone. I have a lengthy paper trail. If she had said to me, that's what this hearing is about today, I would have supplied evidence to that effect. As far as being scheduled for committee hearings and me saying, no, I'm not available, or put it over to another time, that did not happen because I was not notified of any committee hearings. And with regard to any additional complaints that may be in the queue, she doesn't even know if there are any. So a lot of the discussions we had with Cheryl, I believe there are 4 open complaints. I'm not sure. She never got back to me, and I would have to call and leave messages. As of yesterday, I believe, she said, quote, I'm outside the bank, and hung up the phone. I'm like, what was that? What just took place? So I have issues with that. I prepared these hearings. I prepared the documents. I'm ready to go right now on both these hearings. And to come out of nowhere and say, due to inactivity meaning what? Meaning they weren't scheduled. That's the way I look at it. And other violations of complaint procedure. I don't know what I violated. I know I wasn't on the agenda. I wasn't notified of anything, and I made a lot of phone calls. And I have an email paper trail.
Okay, thank you very much. Okay, I put this on the agenda because it was not clear what the status was of these files, and we are cleaning up as many of the old outstanding files as we had, so we could close out 2019. And these were the last 2. What was communicated was that that there was an attempt to try and schedule these. We were told that we could not, that the complainant was not available at those times. Then we entered in, I believe. No. Okay, ma'am, you have to allow us to have the meeting and not interrupt. This is not going to, I'm not going to open this up for debate. I will, if you have a question, I will be happy to call on you. But we need to keep an orderly fashion for the meeting. Thank you. So we would, that was how it's been transmitted to me, and that's why I'm putting it before us, so we can determine whether we want to allow these cases to be moved forward, or whether we should close them. Cheryl, I'll just ask if there's any additional clarification that you want to provide.
Well, I do want to say that she has called me at very inconvenient times, like when I'm running an errand, and I was at the bank when she called on my lunch hour, and then she's called me right before I went into the grocery store. It's never been during business hours.
It's always been during. Oh, okay.
Okay.
I request to be called on.
Okay, I will give you additional time for that.
Thank you. Thank you.
Members, do you have any questions or comments at this time?
Can I ask a question?
Yes.
Yeah.
Please announce yourself. Please announce.
This is Laura Stein. I'm a new task force member. Okay. And I'm just wondering, I can't remember. I've been going through lots of documentation in the last week, so maybe I'm forgetting something. But once someone submits a complaint that's supposed to be heard, what I'm hearing you guys say is that this person was contacted twice and couldn't make it. Is there some protocol for how many times you contact someone if they can't make it? Or, what is, I'm wondering why, why we're at this point. If there's a person who submitted a complaint who still wants to have it heard, why would we dismiss it? Is there something in the protocol that suggests that it should be dismissed?
Right. So we have a complaint procedure, and we'll make several. We will make an attempt to contact both parties to see when they may be available. When we have, we're scheduling these. This is at the particular point in time of scheduling it to be heard before a committee. That would be for if the 45-day rule applies under the public records disclosure part, and or just to determine if it's within our jurisdiction, and to just make sure we have all the information and the collection of an understanding of the particular points of the case. So if any one or the other party is not able to make it, then we will ask for the next time they might be available. If they don't provide us with a time and they would say, I'll get back to you, or they don't respond, then we will attempt, I think, at least once or twice more thereafter. And then there is a provision in the complaint procedure that allows the I think it allows the administrator to actually hold it. I'm trying to find that now. I know there is some allowance for the task force is given allowance to the administrator here. It's item 9 in our complaint procedure. Administrator's authority to table or close files. At the discretion of the task force administrator, complaint hearings may be delayed or scheduled before the task force for hearing to consider tabling the matter if the complainant is unresponsive to communication attempts. After 6 months have lapsed, and at the discretion of the administrator may inform the complainant that the complaint files will be closed unless they provide confirmation of intent to attend a hearing on a specific date. The complainant will be notified of the intent to table or close the complaint files, and the matter will be scheduled before the task force for consideration of tabling or closing the complaint due to inactivity. And that's where we are right now. So attempts were made to try and schedule these. We didn't hear back from the complainant, and here we are.
So am I correct that there were 2 attempts that were made?
Cheryl, is that correct?
I'm sorry, I didn't hear you. Could you repeat that, please?
It seemed like from your recounting that there were 2 attempts that were made.
There were attempts made in late 2019, and then I believe I heard from her in 2020 once saying that she wanted her hearings after March 1st, and then a second time she wanted her hearings after May 1st, and then I didn't hear anything.
Okay.
Nancy,
Hold on 1 second. I just want to get
Okay.
all the
Okay.
task force members first. Member Wong? You're on mute. Member Wong, you're on mute.
Sorry about that. Yeah, I have a question for the petitioner and also our Madam Clerk. I just wondering if there is documentation that was provided on both of your sides for these communications. I don't see it linked in our agenda, but just wanted to double check just so we could get a better sense of what happened.
Nancy?
1 moment.
Okay.
Are you addressing to me first? Member Wong?
Member Wong is asking you a question as to whether there's you have a paper trail.
Whatever paper trail I have would be in the file. And I believe that there were emails from Ms. Trabeau asking that her cases be heard after March 1st and then again after May 1st.
Okay, there's no actual downloadable file for this item.
Right.
So we don't have any of that information. Okay, moving on. Member Frazier?
Yeah, to echo Member Wong's comments, I think that absent having a record, this is going to be hard to address. So perhaps, given that this is my first meeting, could we move to table this item until we have access to a record to be able to adjudicate it?
Sure. We generally use the word continue because we table it. It will then disappear at the end of this meeting. If we continue it to a future time, then it survives the meeting. Member LaHood.
Another thing that we might consider is that since the petitioner has appeared and seems interest in participating, that we plan to recalendar these items and send them to committee and move forward. I understand that Ms. Leger attempted to contact, and I don't want to debate, who I don't want to debate the what actually happened. Since the petitioner has appeared and is interested, I would say let's calendar the items and move forward.
I just want to say one thing. Can I say something,
Yeah,
Chair Wolf?
go ahead.
Yeah,
Mr.
the
Leger.
materials for these two particular cases were not included because my understanding was that this was going to be a decision on whether or not to close the matters due to inactivity. So I spoke with Chair Wolf, and he said not to include the files. This was going to be a discussion, and if it was decided that the cases would be heard in the future, that would be a decision that the task force would come to.
Yeah, I understand that, Cheryl, but if you have a paper trail of the...
No, I agree.
No.
I agree.
I'm not going to debate this. I'm just saying if you have a paper trail of the communications that is leading up to what the discussion around closing the item, that has to be included. The actual case files themselves don't have to be included because that's not what we're considering. We're not considering the merits of the cases. We're just having a discussion as to whether to close the files or not. So any evidence to show that there was inactivity or any other factors leading to us to make this decision, that should be included. That's why people have questions here. So let's go.
Chair
so
Wolf.
I have Vice Chair. One moment. We have other people before you. I have Vice Chair Yankee, and then Member Stein, and then Member Schmidt.
Sure. Maybe me sometime. Thank you.
I will. I'm letting the task force have their time, and then I'll give you yours.
Okay.
Thank you.
Thank you.
Okay, this is Vice Chair Yankee. I have to say that I think Member LaHood's suggestion is really good, as a potential way to get this done, that we obviously know the upcoming committee meetings. And so perhaps we can, have assurances on behalf of the petitioner to, attend one of these. And then if that falls through, then we know that we have given all opportunities to have this scheduled. So, I'm just, on record that I like Member LaHood's suggestion. That's all I have.
Okay, Member Stein.
Yeah, I was also going to sort of second Member LaHood's suggestion, and I guess now Mr. Yankees as well, because clearly the petitioner has showed up. They're interested in having it heard. Even though there may have been difficulties in the past, I would also argue that we should try at least one more time to schedule it and maybe in accordance with her because she's interested in having it heard. So that we have a chance of clearing it that way.
Okay, and Member Schmidt.
Yeah, same for me. I was going to say exactly the same thing. That's all.
Okay, great. Okay, Ms. Chabot, do you have any further comments?
Ann Chabot, petitioner. Firstly, these two complaints were filed early on in 2019. Secondly, I did not receive any emails at all from the Board of Supervisors or from Cheryl Leger's email account prior to the hearing today. I did make phone calls. I did say what's going on. I believe I have 4 complaints in the queue. She could only find 2, and on like that. I have a long email paper trail with asking questions about what's going on with these complaints. Are they going to be going to committee? If so, when? As far back as early 2019. Not consistently, not every 2 weeks, but more like once a month. That's the first thing. The second thing is, she said the hearing today was for lack of communication with the task force. So I rushed to file an answer to the complaints themselves because that's what she first said this was going to be about. And then she later this morning said, no, it's because you were not in contact with us. So she has not supplied any sort of paper trail as evidence to support her allegations that I was notified twice, possibly 3 times of hearings, and I declined the hearings. That is not true, and there's no evidence submitted. The third point I want to make is you read item 9 from your complaint procedures, and you detailed how a complaint is tabled or how it's closed. Ms. Leger did not follow your complaint procedures in this matter. I should have gotten a follow-up one saying, if you don't respond to this email, we're going to close your complaints. There wasn't that either. And I've always had the same email. So I take issue with the procedures here. That's why I prefer to communicate by email, because there is a paper trail. And her claim was that I was calling during non-business hours and she was picking up the phone. No, I'm sorry. I called during business hours. And I was more or less asking the same question, and she didn't have answers. Cheryl, how many complaints do I have in the queue? When will they be scheduled? I didn't waive the 45-day rule, things like that. And, you know, it just was this vague nonsense. So I request to the full task force members that these 2 matters be put on committee as soon as you're able, that I would be available by phone to argue the merits of the case. And hopefully I can get the documents I asked for now 2 years ago.
Okay. Thank you very much. Just note for the record that Member LaHood has left the meeting at 5:01. Okay, members, is there a motion? Member Stein.
Yes, I would like to make a motion that these complaints go to committee. That's correct?
Yeah, that's fine. That's good enough. Is there a
This
second?
is Member Frazier. I second.
Okay, moved by Member Stein, second by Member Frazier to schedule file numbers 19115 and 19126 for committee hearings, and to allow these files to be processed as per our complaint procedure. Vice Chair Yankee?
Yes, I would suggest that we actually name a date of the complaint hearing so that we're all on record and everyone's in agreement on which date that this is going to go on, so that there's no further breakdown in communication after this meeting.
Okay. How about the very next complaint?
Sure, I think that's fine. So I would
committee.
suggest that we amend it to include the February 16th complaint committee meeting.
Okay. Is that okay with the maker of the motion to amend it to that?
Yeah, I mean, that sounds like a friendly amendment, but I would like to check that the complainant is available on that date and time.
Okay.
February 16th? Sure.
Okay, yeah, I would take that friendly amendment then.
Okay, great. And the seconder, Member Frazier?
I second.
Okay.
Bill.
The only caveat I give you is we also do our best to try and make sure that the respondents are also available. And we did not ask them to be here today because we weren't hearing the cases. So I would just also add that if they're not available on any of those particular days, that the very next committee that can hear complaints, that it would be scheduled for. We won't give the respondents too much latitude, but we know that many of them have been taken off their regular work positions to work on emergency services at the Emergency Command Center, and so, might not coincide with our meeting schedule. So just a little flexibility on that. Member Schmidt?
Yes, about the complaint committee meeting upcoming, it may be that because an agenda went out for that meeting, I believe today, that there'd have to be an amended agenda, and so that it may lead to confusion to put this on that for that day. I don't mind adding it in, but maybe for purposes of just clarity, maybe it should be assigned somewhere else.
Okay.
This is Victor Young, clerk. I do not
go
believe that would be an issue in regards to the agenda. The agenda itself has not been posted yet. Only notices to the parties have been sent out. So
Right.
we can schedule for the February 16th if you don't mind it being a little bit of a longer meeting.
I have no problem with that. It'd be great to get some more on for that day.
Yeah.
Good.
Okay, just to remind you guys, we already have 5 cases scheduled for that hearing, for that day. This is 2 more.
Mine will go fast.
Member Schmidt, did you have since you're chair of the complaint committee, do you have a concern about that?
I would also ask Member Yankee what he thinks, but for me, I don't see a problem with that. We just try to move through efficiently.
Member Yankee, Vice Chair Yankee.
I think that's fine. As long as we're efficient about how we conduct the meeting, I think we can make some progress on it.
Okay, great. And just for everybody's edification, as we schedule these hearings to begin at the complaint committee level, we contact both parties to assure that they can meet. And what we do is we initially send out a notice for appearance, and then they can respond to whether that date is, they can make that date or not. And that's how we prepare the agenda. Agendas are posted at least 3 days in advance of any meeting, as per the ordinance. Okay, so we have a motion on the floor. Let's get some public comment other than Ms. Chabot.
Yep. Ready for public comment when you are.
Just a moment. Go ahead, sir.
This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com or at P.O. Box 170544, San Francisco, California, 94117-0544. We're not a party to these matters, and we have no particular knowledge. But we do have a very strong interest in Sunshine working well, and have been, over time, party to many discussions and partial discussions about rules and procedures, and certainly think that if they are as they were more or less, and as we're hearing it, but as they have been in the past several years, they are way too permissive with respect to they were way too permissive with respect to tossing complaints, and especially where there was at one time the possibility of a whole range of exclusionary actions possible by the administrator alone. So the first thing to be said is I was puzzled as I tried to find the file on the link from the agenda, and there was nothing. And I just thought, well, am I doing something wrong or what? And the other links to other items were there. This was not. The idea that you would take an action to deny somebody their right to a hearing under the law because of a procedure which you haven't bothered to document, either as to the procedure or the reason, or even the specifics of contacts and so on, I think is quite shocking. Second, what I heard orally from the administrator was that the complainant said that she wanted to have a meeting after May 1st, and then the task force didn't hear from her. Well, in my view, that puts the ball in the court of the task force. If somebody says, I can't meet any sooner, but after May 1st is okay, to me, that puts the ball in the task force plainly in their court. The idea that we heard from the administrator, she called at very inconvenient times. Well, why did you pick up the phone? Why wasn't there something said about when there should be calls, and so on, and so on, and so on. I'm actually very glad to hear what the task force has said, and I can say that I experienced something very recently of a similar vein. I asked, what's the file number for a complaint we filed in the fall, and got an answer back, no number, have you checked with the library with the recipient of the complaint? It was completely, then the next day we got a number, and so on. Thank you. I think that this should be scheduled, as you said. I'm glad to hear what the task force has been talking about. Thank you.
Next speaker.
Yes, this is anonymous. Let me know when I may begin, please.
Public comment?
Cheryl? Hello?
I wish to make public comment.
Okay, one moment, sir. Waiting for the clock. Ms. Leger?
I think she's currently muted.
Anonymous, I believe you were first.
Okay. May I begin?
Yes, go ahead.
All right. So I agree with what Member LaHood said, and the reason is the very first sentence in your complaint procedure says at the end, all inferences and evidence shall be viewed in the light most favorable to the petitioner, Ms. Trabeau. And also, I do think what the Vice Chair said is correct, because on Rule 9, it says the complaint files will be closed unless they, the complainant, provide confirmation of intent to attend a hearing on a specific date. So I do think you're within your rights to say it has to be on a specific date, and otherwise it won't actually happen. With regards to kind of trying to find a time when the respondent is free, at least according to your rule number 8, it's only the complainant who gets the freebie of continuing, requesting a continuance and having it automatically granted. The respondent actually has to get the approval of your committee or of the complainant, because you do in fact favor the complainant in these processes, since you are, your job is to defend the public. So I would urge you to vote in favor of this motion. Thank you.
Next speaker.
Public comment?
One moment. Go ahead, sir.
On January 8, 2021, I faxed a complaint to Ms. Cheryl here, administrator of the Sunshine Ordinance Task Force, against San Francisco Metropolitan Transportation Agency. I requested that she mail me, which is the way we've been usually communicating for literally years, a copy of the file number for that complaint. Here it is more than a month later, and I don't have any file number that she has communicated to me. I don't understand what's going on. Strangely enough, I've had a very good working relationship with the administrator until now, going back for years, and I don't understand what's going on. It looks like she's, AWOL, doesn't do her job anymore. As I said in a previous meeting, I was so concerned about this that I filed a complaint with the clerk of the Board of Supervisors. I know that's an extreme measure, but this is also an extreme malfeasance on the part of the administrator. This case sounds disturbingly like my own, which is much more recent. All I'm asking for is a file number so that we don't lose track of my complaint. That's all. I have great respect for this task force. In my opinion, it's really the only part of government that works for the people. Good luck. Thank you.
Any other public comment? Okay, hearing no more calls for public comment. Public comment is closed. I will just like to state that in our complaint process, Section 8 is specifically for continuances. And in the scheduling of complaints to be heard is not a continuance. It is a way for us to be able to organize our agendas and make sure that every case that can be heard in every slot that is available in the initial scheduling, this is the process that we use. So the reference to Section 8 of our procedure is really not applicable because we're not really talking about a continuance in this way, in the same way. If it generally that usually comes if we schedule and it's on the agenda and then the respondent says, I can't make it that day, I'd like the item to be continued. That's when the item, Section 8 of the procedure is applied. So it's a little bit of a nuance there, but there is a point at the point of scheduling initially, and then there's a point after it's been scheduled. That's when the continuance actually gets applied. So with that, any other discussion on this item? Members?
Yes, public comment?
No, we have closed public comment on this item. Members, any other? Seeing none, we're ready for a vote. Okay, please call the roll.
Member Stein?
Aye.
Member Stein, aye. Member Fraser?
Aye.
Member Fraser, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
She's absent for the rest of the meeting.
Okay.
But I wouldn't mark her absent. She left the meeting. She was excused.
Do you know what time that was?
5:01.
I'm writing that down. Okay. Member Highland? Member Highland? Okay. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to take this matter to the Complaints Committee in the schedule, item number 19115 and 19126, before the Complaints Committee has passed.
Okay, great. And just a note, February 16th. Okay, great. Now comes to our general public comment. Please call item number 4.
One moment, please.
Yes, public comment, please.
Excuse me, sir, could you wait a minute?
Sure.
Item number 4, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay, speakers.
Yeah.
Mr. Chair, can you hear me?
Yes, I can hear you. One moment. I'm handing this off to the administrator because she has the one with the clock. She will call you in order and tell you when you can begin. And then she will give you a 30-second warning before your 3 minutes is up.
Okay. Who is the first presenter? First public comment.
Cheryl, this is John Hooper. I'm not sure if I'm first, but I would like to make a public comment.
All right, then we will hear your public comment now, right now, sir. Go ahead.
Thank you. Mr. Chairman, members of the task force, first of all, thank you for the important role you play in helping citizens better understand and improve the function and responsiveness of our open city government. I learned around noon today that my complaints, numbers 19061 and 19062, have been placed on the Complaints Committee calendar for the February 16th meeting. And I appreciate your attention to moving these matters along. However, that scheduling does raise a couple of questions that I hope you can clarify for me. At your full task force meeting on December 2nd of last year, your directive to the two agencies involved in these complaints, OEWD and DPW, was that they would respond item by item to a list that I provided so that the complaint committee would be in a position to evaluate the status of the various items that I have been asking for since February 2 years ago. So my question to you is, I'm assuming that you would not have calendared these items on the complaint committee agenda had you not received item by item responses from the two agencies in question. And if that information has been received, as was your explicit directive on December 2nd, then I have to just mention to you that I have not yet received that information, which of course, which is what we've been asking for. So that's really the question. Are the two agencies following the explicit direction that you gave them on December 2nd, and is that the reason that this matter is calendared? That's my first question. My other question is, I sent you an email on January 14th, which corrected several misstatements made by the custodian of records of the Department of Public Works. And I never got an acknowledgement of that letter, which I think is important for you to see and understand. So I renewed my question on January 28th, simply asking for some acknowledgement that my January 14th letter had been received. I still don't know if that information has been received.
Sir, your time is up.
Thank you. I think I don't need to say any more. Thank you very much.
Do we have another speaker?
Yes, we do.
Mark Sullivan.
Okay.
Hold on, Cheryl, hold on. Before we move on, just a quick response for the speaker on just a functional response here. I believe that they weren't scheduled for the complaint committee. They're being monitored by the Compliance and Amendments Committee. That's a charge of the Compliance and Amendments Committee that they may monitor any orders to determination. And I believe that is why the chair of the Compliance and Amendments Committee had decided to put it on her agenda so that it can be monitored. I will forward a message to her asking her to contact you if that's the case. And as far as your other communication, generally most communications that come in are put into our correspondence file. I'll seek that out and have a read on it and acknowledge that it's been in receipt. Thank you. Okay, next speaker.
Who is next, please?
Mr. Warfield, you may go. You may begin.
Okay, thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and also by mail at P.O. Box 170544, San Francisco, California 94117. I would say that in a real meeting before COVID, people could walk up to each other and say, gee, I really liked what you said, blah, 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 and, or I didn't, and here's why, and I think, and so on. First of all, hello to the new members, and I'm so far very pleased with what I've heard. We have brought complaints over quite a few years, won most of them, and have had a lot of experience as well with Sunshine in general and meetings in general. Overall, I'm glad to see that there is, in the agenda, what looks like a lot of discussion and clarification about what's going on with respect to procedures, with respect to the new regime under COVID and so on. I think I have been requesting that this be clarified for the public and preferably documented for some time. The new regime has new rules of all kinds with respect to meetings, with respect to participation, and so on. It's one of the issues that I have with the huge backlog that the task force has, and that is that uniquely new issues, for example, the difficulty that people have getting into meetings, none of those things seem to be dealt with currently and don't look like they will be until quite some time well into the new regime. There are problems, for example, with people participating in the remote meetings, poor instructions or none. So, for example, your own agenda today, unlike the Board of Supervisors, doesn't appear to have anything. Is something beeping there that could stop? Your own agenda does not have any instructions for how to participate other than to provide a phone number and a meeting ID. So, for example, what do you have to press to talk or to mute? What are technological problems? I've been to meetings where I've called on time and been told I can't get in because the meeting hasn't started yet, and yet it's a minute or two after the start time. Larger issues with respect to the Sunshine Task Force.
30 seconds, sir.
Everyone gets a lawyer except the public. The agencies of the city have legal assistance throughout their operation and in responding to complaints. You have a lawyer, but the public does not. It would be really helpful if there were an ombudsman or legal assistance. It would be helpful for you to have a record, a history of your determinations specifically by section of the law or by subject. And many times those are different sections of the law, like cost for copies alone has multiple sections. There are a lot of things that can be done to help the public, and I hope you consider those as you go forward. Thank you.
Do we have another speaker?
Anonymous.
Mark.
Did I hear two people?
Ann Treville.
Mark Sullivan.
Ms. Trebo,
There are
Mr.
two
Sullivan, and Anonymous?
Yeah, I can go at the end. That's fine.
Okay. Ms. Trebo, are you ready?
I'm ready.
Go ahead.
I'm just very interested in the impeachment of Donald Trump. I'm wondering how the claim of First Amendment right, which his lawyer is putting forward, how that relates to the events that took place around the Capitol and in the Capitol, which were shocking. I have been following it very carefully. That's it.
Do we have another speaker?
My name is Wayne Shapilier. I'd like to speak.
Mr. Sullivan, do you want to go next?
Sure. Ready?
All right.
Speaking to the discussion of attorney-client privilege on your January 12th meeting, official information privilege allows a public official or public agency or a task force such as yourself to withhold information submitted to them in confidence until and unless it has been expressly relied upon in making a decision. If the public interest in such secrecy outweighs the public interest in disclosure, this is San Gabriel Valley Tribune versus Superior Court, 1983, where the task force has a balancing test of where you would have to demonstrate to a judge that the secrecy of withholding outweighs the public interest of disclosure on how your decisions are made. This is a case-by-case basis and goes down to whether an individual on the task force has relied on privileged information to make a decision on their vote, especially in a close vote. Sunshine Ordinance 67.1a, government duty is to serve the public, reaching its decisions in full view of the public. If the public interest in withholding those records clearly outweighs the public interest in disclosure, shows up 10 times in the California Public Record Act. The interest of the government and the public should not be divergent. Any divergent is self-interest of an individual or individuals. I would urge the Sunshine Ordinance Task Force to make all information public that it uses to come to any decisions. This public comment has already been submitted for the record. Thank you for your time.
Hi, this is Dante Tedessa.
Go ahead, Mr. Tedeschi.
Thank you. Please give me a 30-second warning once I come through. Sunshine Task Force members, that's again. I am still on the quest of seeking justice and fairness in my cases, which I have not gotten. Case number 18010 was filed against the city attorney's office after I wasn't able actually to attend. File number 18010 and 18028, which has, the first one was the city attorney's office and the second one was the sheriff's office, which I filed after I wasn't able to actually attend the meeting for the city attorney's office on March the 27th, 2018. I then filed I emailed the Sunshine Task Force administrator saying that I was unable to enter to actually attend that meeting against George Cothran, chief investigator of the city attorney's office, for improper handling of my personal papers that he was serving. What happened next was the administrator filed the sheriff's office complaint 18028 as if I had filed it back in February, when I did not. I filed that after, and I filed that in direct response to me not getting into that meeting on March 27th, 2018. Because of that meeting, I wasn't able to get in. That file number 18010 was held over all the way until April 16th, 2019. Now, I said that was a surprise, that I just came up out of nowhere, because I was under the understanding that if I had submitted more information, because I got a call from the administrator saying that you will not hear it unless I provided
30
more
seconds.
information. I have asked this task force, I've called in many times to talk about my concerns regarding this situation and these two file numbers. I have gotten no response. I don't know. Do I file a complaint against you guys? I don't want to, but that's where I'm going. And I just want you to look into this, please. 18010 and 18028, which actually I got a determination against the sheriff's office. Look into those files and please tell me if that was proper. Thank you.
Is there more public comment?
Yes, madam. My name is Winship Hillier. I'd like to comment.
Go ahead, sir.
Thank you. I've heard it said that Charter Section 4.104b applies to this task force, and even that some members had been recently kicked off the task force for insisting that it did not. I myself have thought it applied to the Behavioral Health Commission. Both contentions are, I believe, wrong. Here is why. In 1971, the voters of this city approved a new charter. Section 3.500 of that charter was the law for boards and commissions. It began, quote, each board and commission appointed by the mayor or otherwise provided by this charter shall have powers and duties as follows, colon, end quote, and then laid out numerous requirements under subdivisions A, B, C, etc. Each of these requirements made reference to the scoping language at the start of the section, i.e., each board and commission. Among them was subdivision A requiring that executive department boards and commissions adopt a rule prohibiting abstention votes. For many years under this charter, everyone lived and prospered and loved one another, and there was peace throughout the city. In 1983, the Board of Supervisors adopted Administrative Code Section 1.29. This section extended the requirement of adopting a rule prohibiting abstention voting to boards and commissions created by the legislative branch, such as the Task Force and the Behavioral Health Commission. It even borrowed some of the language from Charter Section 3.500. Then in 1996, the voters approved a new charter. The new charter split up the old Section 3.500 into different sections of Article 4. It propagated the scoping language to some sections, but not others, such that some sections appear to apply to boards and commissions generally, yet others mentioned the executive branch, and still another mentioned both the executive branch and the legislative branch. Confusion reigned in the city. Brother turned against brother, child against parent, and dissension and disputes were the orders of the day. Section 4.104b also changed the abstention prohibition. The layer of indirection requiring that each board and commission pass a rule was removed, and the prohibition became a direct order. Abstention voting was prohibited not by a rule required by the charter, but directly by the charter. 3 years later, the legislature amended Section 1.29 of the Administrative Code, taking out the layer of indirection from that provision as well.
30 seconds, sir.
Clear that Section 4.104b pertained only to executive branch boards and commissions. Or if it had extended to boards and commissions created by legislative act, then amending Administrative Code Section 1.29 would have been a useless and idle act, never to be presumed of a legislature. Back to you, Madam Clerk.
Hi, this is Anonymous. May I comment?
Go ahead, Anonymous.
Thank you very much. So I have bad news and good news. I'll start with the bad news. Your compliance committee recently made a decision to close out the long-standing case Andrews versus Public Defender case, but I believe you made the wrong decision. You decided, or the committee decided, that certain emails were not public records because they were about a meeting that is not a public meeting. And I can prove that this decision was wrong because I actually requested those records myself. I actually got the records from the Public Defender's Office with far fewer redactions than they gave the complainant in that case. So I urge the full task force to somehow reconsider the compliance committee's decision. But on the good news, the Chief Information Officer, Linda Jarrell, has informed me today that they expect to have a production version of the software that will automatically release electronic metadata in public records by April 1st. And as you know, this is only a result of also this task force's long-standing work and 5 orders of determination in my favor regarding this issue. It's really great that this is finally coming to fruition. And on the future meetings of public officials issue, you made 2 orders of determination that the mayor and the chief of police must produce their future calendar entries before the meetings occur if they're requested. And the mayor has claimed she will comply. She has not yet. But the city attorney has actually proactively complied and changed his mind, his legal opinion. And even before you've issued an order against him, he has decided that he will disclose his future calendars subject to certain constraints regarding security procedures, which is understandable. And that's great. We're now going to see if the supervisors will comply as well. And finally, DPA and SFPD have actually agreed to comply with the Sunshine Ordinance and produce justifications, keys, etc. For the other 2 complaints I brought. So this is really great news, and this is exactly why I do this, because I want systemic change across the entire city to comply with the Sunshine Ordinance. And that's what the voters demanded, and that's what the public deserves. Thank you very much.
Any other speakers? Last call for public comment. Vice Chair Yankee?
Yeah, just to get back to the original public commenter, Mr. Hooper, I think he asked a question regarding his files, which were 19061 and 19062. As the other public commenters were speaking, I went back and looked at those meeting minutes, and in the December meeting, we had referred the matter back to the complaint committee, actually. So it looks like that's the notice that he got, was for the next complaint committee that is agendized on.
Okay, I appreciate that and stand corrected. Okay, seeing no further public comment is closed. Let's move to the next item.
Item number 5, file number 20010, complaint filed by Patrick Monette Shaw against the Office of the City Attorney for allegedly violating Administrative Code Section 6721B and 6725D by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Okay, are both parties here? If you're on the phone, you can unmute yourself by pressing *6.
That's Shaw.
Okay, Mr. Shaw, Monette Shaw, is somebody from the City Attorney's Office here? Is there a representative from the City Attorney's Office? Cheryl, did you get a response from the City Attorney's Office that they will attend today?
Yeah, that was my understanding. I certainly sent them an invitation.
Okay.
They got notice of it.
Did you get a response from them?
If I did, it would have been provided in the record.
Okay. Okay, members, it is not a requirement that the respondent be present, but it's up to you if you wish to hear the complaint moving forward. Shall we continue?
If I could,
Vice Chair Yankee.
Just a quick question on this one. Did the city attorney attend? It looks like this one did go to a committee first. Did the city attorney attend that committee hearing?
I'd have to look at the minutes.
This is Patrick Monette Shaw. I can ascertain that John Cote was on the Compliance Committee preliminary hearing on November 14th. Yes, they attended that hearing.
Okay, thank you.
And note that on page 41 of the packet that they submitted their response. Okay, I'm not hearing any objection or calls for continuance. I'm going to suggest that we move forward with the item. If the respondent does not agree with the order of determination coming out of this hearing, there's process of appeal through reconsideration that they can submit to us. So with that, you don't have Chair LaHood, Chair of Compliance and Amendments Committee here, but I believe that this was just a simple jurisdictional finding, and the records were found to be public, and so it is now before us. We'll start with our regular procedure. It'll be 5 minutes for each party, plus any additional witnesses for either party. Then we, after we hear the opening testimony, will be a period of question and answer to provide more clarification about the merits of the complaint. Then we will hear rebuttals from each of the parties. After that will be a period for deliberation and a time for us to make a motion and figure out how to dispense with the rest of the case. Okay, so in that middle period, there's a big difference between the first period that we have, which is a Q&A. We're specifically asking questions, trying to gather more information. And in the second part is deliberation on what we're going to do about this case. Okay, just so we're clear, it makes things move along very clearly for everyone. When I do ask that when you want to speak, please announce yourself, members, so that the public knows who's speaking, since they cannot see us. Okay, Cheryl, are you ready with the clock?
Yes, I am.
Okay, great.
Mr. Manette Shaw?
You ready?
Thank you, Cheryl. Thank you, Cheryl. Please give me a warning when I'm 1 minute
30
away from.
1
All right,
minute.
fine. All right.
1 minute, fine.
I'm Patrick Manette Shaw. I want to congratulate the new task force members on their appointment. Welcome to our watchdog for public records. I'll be brief. The task force should be able to dispense with my complaint quickly and rule in my favor. I forgot to include in my initial complaint, dated January 17, 2020, that California Government Code Section 6253.9A2 was eventually incorporated into CIPRA, the California Public Records Act. It provides that any state or local agency which stores information in electronic format, such as computer databases, the local agency must make the information available. Section 6253.9 explicitly requires city agencies to extract data from their departmental databases, whether in Excel or a custom or off-the-shelf database package. Mr. Cote's comical defense during the preliminary task force subcommittee hearing on this complaint on November 24th asserted that my immediate disclosure request, hereafter an IDR, was converted to a standard records request because, get this, in his words, the city attorney's office was not required to create new records. That was pure nonsense, precisely because no new records were required. Instead, all the city attorney's office simply had to do was extract existing records from its attorney time and expense reporting database that is typically updated daily as its attorneys perform work on any given lawsuit. The lawsuit information I was requesting was for city employees who had sued the city for a variety of prohibited personnel practices, and those cases that I had requested were all closed. I had placed my IDR on December 28th, 2019. The next day, the city attorney's office responded on December 29th, saying it was converting my IDR to a standard records request to find the records and conduct an extensive review of them and invoked a 10-day delay, specifically stating it would respond by January 6, 2020. No such extensive review was required, and it should not have taken 10 days to find the records in its attorney time and expense reporting database. CAO staff must have known they could instantly find the records by turning to its time and expense database. After stalling for 10 days, the CAO invoked a second 14-day extension. There was no need to review the 111 lawsuit settlement records they eventually coughed up, since there was no attorney-client confidential data in any of the fields of information I had requested. They didn't need to review the data. They just needed to provide it. Please rule in my favor, finding violations of Sunshine Section 67.25D and 67.21. They should have provided record or responsive records on a rolling basis, which they did not do. And also, I would like the task force to find that they should not have invoked a 10-day extension and then invoked a second 14-day extension for a total of 24 days, taking 2 bites out of the apple. Thank you.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner, the complainant? Seeing none, respondent, is there a respondent present? Calling for the respondent from the City Attorney's Office. Any representative from the City Attorney's Office? Okay, hearing none, we'll note for the record that there was no presence of a representative from the respondent, the City Attorney's Office. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Okay, hearing none, members, the file is now with you. Any questions or answers, clarification from any of the parties? Member Stein, you're on mute.
Sorry about that. Yeah, I do really wish that somebody was here from the City Attorney's Office, because I definitely had questions for them, including, what the process was to find these records, because I couldn't get a sense of how much time it would have taken them and all of that. But I do have a question for Mr. Shaw, I guess, since he is here. I saw that, he's requested similar records at least 4 or 5 times in the past. And I see the first time he requested it, it took 1 day to respond or to get his records. And then the next several times he requested it, it took 12 to 14 days to get those records. And I guess for me, this case kind of hinges a little bit on how much work was actually involved in getting the records. And I have to say, I found the CAO response was not very clear. It was kind of vague, even though the task force had requested that that they kind of give a more detailed description of the process used to get the records. So I'm just wondering if Mr. Shaw has any sense of what that process is or had been in the past, why it had taken 14 days in the past to get those records.
Ms. Stein, I'm Patrick. I thank you for your astute question. Just FYI, I retired from city employment 6 years ago after working for 16 and a half years for the city. My first decade of employment was at Laguna Honda Hospital, where as a mere secretary, I assisted a senior physical therapist developing a Winchester House style, custom grown, homegrown database in Microsoft Access. And part of my duties was to write what's called cross-tab queries. They're underlying database queries to extract certain fields of information depending upon what information is being sought. The database under question at the city attorney's office, I believe, is called City Law, and it tracks city attorney time and expenses for each lawsuit that the attorneys are working on. The attorneys enter that time and expense data daily as they work on cases. And my humble opinion as a secretary is that if I could write cross-tab queries to extract data from various fields in a database, so too could either city attorney staff or the city attorney's information technology professional staff. And they should not have taken, it should not have needed, wait a minute, I'm sorry. When I would have to write custom queries that were not canned or pre-stored queries, typically it would only take me 15 minutes or less to write a query to extract the data. Then I might spend more time making it look pretty by formatting a detailed custom report. But the underlying query typically takes 15 minutes or less. Either CAO staff or CAO information technology staff should have been able to extract that data and provide it on the same day. They didn't need a 5-day or a 14-day or a 24-day exhaustive process to extract the records, and the claim that they needed to review each of the eventual 111 records. We're talking a page and a half of data. They didn't need to review that data because they couldn't change it. And the fields of data that I requested are formatted such that they could not have put in attorney-client privilege data in those data fields. So there was essentially no need to review the records because, in fact, I was asking for cases that were completed. They could not have gone back and adjusted the billing data on completed cases, so there was no need to review it. Has that answered your question?
I mean, yeah, I think largely. I just wondered why, I saw that the first time you did it, it took a day, and then several other requests took 2 weeks. Did this request did the data that you got look pretty much like other data that you'd received in the past in terms of the fields and what was there?
Absolutely, because I gave them repeatedly over the years. I would provide sample reports that they had provided to me back to them so they could see what I was looking for. And with all due respect, at that point, it should have been a canned report, a simple procedure of just going in and only having to change the date range of the period of records that I was searching for or wanted records for, that they just had to refine an existing query and simply change the beginning date and the ending date. It was a very simple chore.
Okay, thank you.
Any other questions? Member Highland. Welcome.
Thank you.
And then
Mr.
Member
Manette
Fraser.
Shaw, just to follow up on that question, was any of the material you did eventually receive, was any of it redacted in any way, shape, or form?
No, not at all.
Okay, thank you.
It is consistently unredacted information. The name of the city employee has never, ever been redacted. The court case number has never been redacted. The amount of the settlement awarded to the city employee has never been redacted. And nor have any of the city attorney expenses and the city attorney time spent on the case, none of that has ever involved redactions.
Okay, thank you very much. So members, as I imagine you probably know, the new members, the city attorney's office is very experienced in sunshine matters. It's just quite cheeky that they decided this wasn't an IDR and then they decided to give themselves a second extension. So I certainly see a violation of timeliness at the very least, and that's kind of where I am on this. Thank you.
Okay, we'll have more deliberation after we hear rebuttals. We can formulate that. I have Member Fraser and then Member Schmidt.
Yeah, thank you. I think in response to Member Highland's comment, I'll wait until deliberation to further discuss how we've kind of responded to IDR comments or responses to IDR evaluations when it comes to what constitutes a non-routine production. So eager to hear and talk further with the board.
Member Schmidt. You're muted.
I apologize. A couple questions for Mr. Manette Shaw. There's a case that I want to ask you if you are familiar with Sander v. State Bar case. It's a 2000.
I am a mere retired secretary.
Okay.
I have been placing public records requests with the City and County of San Francisco for 20 years. No, I am not familiar with that case.
Okay.
And I want you to know I am a columnist for the West Side Observer newspaper. I've never heard of that case.
Okay. Thank you. I just thought if you had familiarity with a case, it might change how I ask you the question. It's a case that is very recent. I think it's 2018 or 2019. And what the Supreme Court in that case talked about was the standard for when is a request asking for the government to merely extract data versus to create a new record. And it looks like to me what I'm going to ask you a couple questions about is you were asking that certain information be provided to you in an Excel format. Is that correct?
Yes, Excel. They have provided it in PDF format in the past. Typically, they come to me more often as simple CVS. What's the file format for CVS or CSV files? They're just raw, comma delimited fields. They could have just sent me that, but when you take CSV data and dump it into Excel, it automatically puts them into separate columns, separate fields of information.
Didn't you make a request that they put this into Excel format for you and to create an Excel documents for you?
I did, because I assumed they were not going to send it to me in their native database, that they would have had to send me the database software for me to open up a database file. And I believe the state law I cited to you that has been incorporated into the California Public Records Act requires them to extract the data, and they have to extract it into something. So they were not creating a new record. They were just creating current records and dropping it into some format that they could forward it to me. They would have had to do that whether I requested a specific format or not. And let me just add that California government code says that they can charge me for programming time in which to extract the data. The city attorney's office has never done that. They have always provided it without cost.
But you asked them this time, please put it into an Excel spreadsheet. Isn't that what I saw in the file in the letter that you sent to them?
I may have, but what has that got to do with anything? They have to put it into some kind of format.
Okay.
Wait a minute. They could have dropped it.
You answered my question. Yes, you did. Okay. And I'll tell you what it has to do with. They are obligated to extract, but the CPRA has been interpreted. If you ask them to do more than to extract and to actually manipulate the data in a way, or to manipulate or restructure in some way, then that is a request for the creation of new documents. That is my reading of the Sander v. State Bar case. Now, wouldn't you agree that that's what your request was when you specifically said you wanted Excel spreadsheets created for you?
Well, I did, but I think your point is specious, sir. They had to give it to me in some format. They could have dumped it into the body of an email and I would have accepted it, and they didn't do that. And they have never quibbled about whether extracting the data and quickly dropping it into an Excel file was problematic for their hairdos.
Okay, I have no more questions. Thank you.
Okay, Member Padmanabhan.
Yeah, I think on the same lines, I do wish someone from the city attorney's office was here today to answer the question of what constitutes a new record and what is the procedure for creating a new record. And I don't know.
You know what? They have never raised that in any of their responses to me. This issue may be of interest to the newer task force members, but it has never been of interest to the city attorney's office. And I say that respectfully, folks. I think you are barking up the wrong tree.
Any other questions, clarifications from any of the parties present? Okay, let's move to rebuttals. The respondent, 3 minutes for rebuttals from each party. The respondent goes first. Is the respondent present? Hearing no response, note for the record, there is no response from the respondent. Please start the clock for the petitioner. 3 minutes.
Mr. Shaw, you
I'm
ready?
sorry, what?
Mr. Shaw, you have 3 minutes to do your rebuttals. Tell me when you're ready to begin.
Okay, I'll again make this brief. I don't have anything to rebut. They have consistently provided these records before without ever quibbling over whether they are creating a new record. So, again, with all due respect to the new task force members, I don't think that issue is germane. The only thing that is germane is whether they needed a full 24 days to provide the records when they had provided them more rapidly in the past. And frankly, it should not have involved anybody having to spend more than 15 minutes to extract that data and provide it to me, even in the body of an email. Thank you.
Okay, that concludes the main part of the hearing process. Now it's time for deliberations. Floor is open, members. Okay, Member Stein, go for it.
Yeah, I just want to say I'm still, I've read the Sunshine Ordinance of 1999, and I'm still working my way through the California Public Records Act. But I really don't think the question of whether this is a new record is at issue here. And just even from my, halfway through the California Public Records Act, it makes allowances for, requests that require the search of databases or the compilation of information that's contained in a database. And what they say there is that if there's some kind of extensive, they say that there might be a need for a delay if it involves compiling or extracting. I guess I should read the whole thing. The need to compile data to write programming language or a computer program or to construct a computer report to extract data may be reasons for the need of an extension. But even the way that the Public Records Act is written, it sounds like you would have your 10 days and then you could potentially have a 14-day extension if you're having to write programming. Where this doesn't meet up is with the whole IDR process in the Sunshine Act, which says 1 day, right? So it seems to me like the appropriate thing might have been 1 day and then maybe requesting a 14-day, or saying they were going to have a 14-day extension because they were going to have to do a bit of programming. And I guess I just want to reiterate that I'm kind of disappointed that the city attorney's office didn't really talk about the process that they needed to create that record or to potentially redact materials or all of that. So I just wanted to raise that point.
And I would like to say that they have never...
No, Mr. Shaw, you had your time, and now it's with the task force for deliberations. Thank you. Members? Unless you have questions for more additional clarification from either of the parties, the time is just between us to deliberate and formulate a motion finding in violation or not. Okay, I will add this. This is not the first time this kind of case has come up before us. It's not unique. The printing of a report out of an existing database is pretty regular manufacture Most databases do allow exports of many different kinds of file formats. We don't consider that to be programming. Programming would mean actual creation of software or additional types of special queries or scripts to be able to perform a new function that doesn't exist. That is what we have determined, and our previous orders of termination have taken a position on. That said, I'm very concerned that especially the city attorney's office would go as far as to convert an IDR into a regular complaint. The task force has ruled many times that that is incorrect and improper use of implementation of the law. The Sunshine Ordinance, of which is the only place that an IDR exists, doesn't provide or allow for anyone to convert an IDR into a regular request. Third, the reason why we have a Sunshine Ordinance is because state law under the CPRA and the Brown Act allow for an enhancement of either both of those laws independently or together for additional expediency and efficiency that would increase transparency of government. So the Sunshine Ordinance actually is the law of the land beyond the CPRA in this case, because it provides additional enhancement in these areas. That said, if we didn't have a Sunshine Ordinance, then the period of time for response would be 14 days. Okay, I believe if the CPRA was amended, and it was amended to 6253C, where it says each agency upon a request a copy of record shall within 10 days from receipt of the request determine whether the request in whole or in part seeks copies of disclosable public records, okay, of the agency shall promptly notify the person. It doesn't speak about delivery of records there in 6253. Nonetheless, the Sunshine Ordinance provides an enhancement of that. And the enhancement is in 6725 of the Administrative Code, notwithstanding the 10-day period for response to a request permitted under Government Code section, and it should say 6253 at the time this was passed. I think that's a typo, actually. And this article, a written request for information described in a category of non-exempt public information shall be satisfied no later than the close of business of the following day of the request. What that means is that it takes 10 days if it's just CPRA, but under Sunshine Ordinance, it reduces that down to the following business day for just a response. Yes, I received your IDR. We do or do not have the records. This is when we will provide them. We will either provide them immediately or we will provide them in now taking an additional 10 days, as you'll see in B, if the voluminous nature of the information is requested, so on and so on, it can provide an extension of 10 days. Okay, so that is kind of the operation of how an IDR is supposed to work. Now, if there is extensive case law that refutes this or overrides it since the creation of the Sunshine Ordinance, I'd be interested to hear that and see how that is applicable for this. And also, we do have a appointed member of the bar in Mr. Schmidt here, but we also have our legal counsel who's present here at the meeting, who is assigned by the City Attorney's Office, DCA Mark Price Wolf, that we could also ask questions of with regard to this also. I see Member Highland's. I saw Mr. Frazier, Member Frazier, and then Member Highland.
Yes, hello, and apologies that my camera is off for right now. I wanted to point out that the new records portion of the California Public Records Act has been interpreted to say changing the substantive content of an existing record or replacing existing data with new data. And so even if there were some degree of having to compile something into a spreadsheet and formatting it in a particular way, I don't see that as changing the substantive content of an existing record or replacing existing data with new data, but merely organizing data. So I'm inclined to say that this wouldn't be a sort of new record under that kind of two-pronged analysis.
Can you give the citation, please?
Yeah, sure. That's Sanders versus Superior Court in the 1st District of California. And that was, 1 second, from 2018. And I'm happy to post in the chat a full citation of that case.
I wouldn't do that. The issue here is unless the question is of us members, if we want to consider that as being a factor, that's fine. But if any member wants to have time to read through that and become more informed in that, then I would suggest that the file be continued, because that may bring up additional arguments or debate around that. But I hear you. I think it's a very good citation. Let's move to Member Highland, and want to try to wrap this up because we have one more case, and then we want to move into our main section of the meeting for orientation. Thank you.
Yes, thank you. So the petitioner calls for violations of 6, 7, 21, and 25. 6, 7, 25 B is a violation because this is an IDR. The only thing the CAO did correctly was to respond on the first day. That it did correctly. To try and convert the response was incorrect. A 10 and a 14-day extension is incorrect. So what they should have done is respond on the first day and then asked to do this on a rolling basis. So I do see a violation of 6, 7, 25 B. Going back to 6, 7, 21, I don't see a violation there, except as a task force, if we want to, we could add in 6, 7, 21 E, failure to send someone to this hearing. They did go to the subcommittee, but not to this one. But I'll leave that up to, we can separate that as a separate motion if you like. But I'm convinced by the petitioner that what was provided, now that he has it, arduous to produce, was not publicly exempt, and so none of those arguments, the CAO's response on page 41, bear any weight with me. So just at the very least, I'd like to make a motion on 6, 7, 25 B for timeliness.
Okay, there's a motion for 6, 7, 25 B for timeliness. I see your hand, Member Schmidt, but with a motion made on the floor, I'll ask for a second.
I'll second it.
It's moved by Member Highland, second by Member Forsley. Okay, now Member Schmidt.
Yes, this is Member Schmidt. Referring to our new member Frazier's comment, yeah, I think that it's odd that you said Sanders was a case you looked at, and the case I was citing is Sander. I assume those are different cases, but I think whether it's Sanders, whether it's Sander, and maybe they have slightly different wording, but I'm kind of on the fence on this, whether I think there is a request to create a new document, but I think that our issue here is this within the requirements that are out there, that you do have to create certain things. You do have to supply certain things, but there's a certain limit. And I don't know if he's over the limit, under the limit. So I don't know if I'm completely happy with whether we have the law fleshed out on this thing. But that's just where I'm at on this thing.
Okay. Any other members? Anything else before we call public comment? Okay, let's move to public comment. This is public comment on the motion to find a violation of 6725B on timeliness of disclosure of the records.
Yes, please. Anonymous here. Hello? Can anyone hear me?
Leger? You're on mute, Cheryl.
Yeah, just a second. Anonymous, you may begin.
Thank you very much. So I think you should vote in favor of this motion, but I want to address, and I think it's a very important citation that Member Schmidt made. I would agree with Member Schmidt if we were not in San Francisco. But in San Francisco, there's an additional thing that considers generation of an easily generated file format to still be within requesting a public record. And that citation is Administrative Code 67.21L. And I bring it up because you've used it in many cases to rule in my favor, similar but not really the same issue. And if going from a database, if you consider creating a CSV file or an Excel file format, quote, either available or, quote, easily generated by the department, then you should rule in Mr. Shah's favor. And I think it's pretty obvious that an Excel file or a CSV file are in fact, quote, available or easily generated electronic formats. And therefore, I think that they should have met all the timeliness requirements that the Sunshine Ordinance would say. And that is Admin Code 67.21L. Thank you very much.
Thank you. Next speaker.
Somebody on the list?
Do we have two speakers waiting?
Who is next, please?
Mr. Warfield, you can be next. Go ahead. I'll give you a 30-second warning.
All right. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and by U.S. Postal Service, P.O. Box 170544, San Francisco, California 94117. We're not a party to this and are not familiar with this, but we do agree with the passage of the motion, but I wouldn't want there to be a lack of discussion of a violation of Section E for Edward. This is where the law requires the presence of an authorized representative of the custodian of the public records. And I'll read it because it requires attendance at any hearing. An authorized representative of the custodian of the public records requested shall attend any hearing and explain the basis for its decision to withhold the records requested. this is important, and by the way, this is also something that I've talked about a little bit earlier or touched on, and that is there is not a requirement posted here that the complainant appear. It's possible that the complainant has information or evidence sufficient to show that a violation occurred or likely occurred or possibly occurred, and on that basis there can be requested a hearing. Your rules, on the other hand, basically say if the complainant doesn't show up, the penalty there is that they don't get a hearing. The law, in fact, requires the respondent to be present, and whether you have that as part of this motion or whether you consider it as a separate motion, I think it's vital that you enforce this requirement. It's there in the law. And it's also necessary for you to get some sense of what's going on and why and so on and so forth. Not to appear...
30 seconds, sir.
Not to appear on the part of the respondent is to violate the law, as well as to cause various harms that we could go into separately. But while I agree with the motion as it stands, if it will add something as a separate motion or add it to this motion, then certainly we would agree with it. As far as it goes, we certainly support it. Thank you very much.
Next speaker.
Do we have another speaker?
Please press *6 to unmute yourself if you wish to speak in public comment. I thought I heard Mr. Tedessa. Mr. Tedessa? No. Okay. All right, members. Any last thoughts? Are we ready for a vote? Okay, seeing no objection, please call the roll.
Can we restate the motion?
Motion
Yes.
is to the motion is to find in violation of 6721B for timeliness on disclosure records.
Is it 21 or 25?
I'm sorry, 25B.
Okay. You ready? Member
Please call the roll.
Highland. Yeah. Member Highland.
Aye.
Member Highland, aye. Member Forsley.
Aye.
Member Forsley, aye. Member Frazier. Member Frazier.
Aye.
Member Frazier, aye. Member Padmanabhan.
Aye.
Member Padmanabhan, aye. Member Neighbors.
Aye.
Member Neighbors, aye. Member Stein.
Aye.
Member Stein, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member Wong.
Aye.
Member Wong, aye. Member Yankee.
Aye.
Member Yankee, aye. Member LaHood, not present. Chair Wolf.
Aye.
Chair Wolf, aye. The motion to find a violation of 6725B for timeliness for non-disclosure of records has passed.
Okay, great. Any other?
Could I
No.
have the vote? Could I
No.
have the vote results? What was it? 10-0?
Yes. I'd like to make a motion to find the respondent in violation of 66721E for not appearing.
I'll second that.
So moved by myself, Chair Wolf, second by Vice Chair Yankee. Any discussion?
This is Member Forsley. I just want to put it out there that it is during COVID and stuff, so it's kind of a situation where I know that we're all supposed to be present, but I just want to obviously put it for the record that there could be some circumstances involved.
Noted. Okay, let's open it up for public comment. Any public comment on to find a violation of 6721E for non-appearance?
Anonymous, yes.
And me too, please.
Anonymous, you may begin.
Thank you. I think you should vote in favor of this motion. It is the case that certain exigent circumstances come up, but the rule, or at least the courteous thing to do, is to just email Miss Leger. It's happened in my cases, right? Like a firefighter once died and the police department couldn't represent itself because they had to go deal with that. And they let Miss Leger know, okay, well, we can't make it today. And, ask for a continuance or whatever they want to do. But it's not fair to just not show up, even if you have COVID duties, even if you have other things to tend to. At least tell the complainant and Ms. Leger just as a courtesy. So you should vote in favor of this motion. Thank you.
Next speaker.
Is that me?
Mr. Warfield, you can begin.
This is Peter Warfield, Executive Director of Library Users Association.
Folks, can you please mute yourself? Victor, can you please mute? Thank you. Go ahead, speaker. Go.
Is my time going to be reset or what?
Yeah, we'll
reset your time, yeah.
Victor, if you're still there, I don't think he's still here, actually.
What?
I don't think Victor's still here. Okay.
Yeah.
All right, Mr. Warfield, please restart the clock. Thank you.
I did. Mr. Warfield, you may begin.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and also by mail, P.O. Box 170544, San Francisco, California 94117-0544. Thank you to the chair and the vice chair for making this motion. I think it is very important, and I think it's also just a matter of self-respect for the task force and its role in these hearings. The member who suggested that there could be a COVID-related issue, well, that is certainly true. And there might be a whole range of issues, but the city attorney's office, as I understand it, has about 250 attorneys and presumably a management structure that would be capable of handling almost any kind of a situation, either by providing a substitute or a backup person, or by doing as Anonymous has said, and as Anonymous apparently has experienced, and that is you let the task force know through the administrator or the chair that you're not going to be able to make it. It's frankly a slap in the face when a supposedly professional agency of the government can't do the most basic, simple kind of dealing with a matter having to do with being someplace at a meeting or whatever else is necessary. Yes, maybe sirens and arrest ought to be the punishment and not just a finding by the task force. I hear the sirens already ready. Thank you for propounding this and putting it forward, and I hope that you vote unanimously. to find a violation. You might even put some sharp words in there.
30 seconds.
I do think it's a disrespect to the process, to the task force, and to all the participants. Thank you very much.
Next speaker.
Yes, this is Dr. Deleta.
Just a moment, sir.
Thanks.
Go ahead, Mr. Tedeschi.
Yes, yeah, I definitely agree with this. I think that something, this is just purely speculation, but I see some similarities to some strange similarities to my case as well, and just the surroundings regarding the city attorney and settlements that they make with employees, especially MTA employees here in Texas. So the reason I'm saying this is when I had my complaint against John Haley, the harassment case that was settled by the city was with the administrative assistant. I believe she was then Suzuki, Sabrina Suzuki, I believe her name was, and I say that this has something to do with this because in that case, the my own case was delayed, and actually happened after John Haley was resigned, and after the director of transportation resigned as well. But the settlement agreement for that was split between her and the attorney, and I thought that was weird. And reviewing the case file for this one, the Joshua Fidel issue that the complainant has said there's a difference in payments and all that stuff. I find that strange, how a city attorney's office is representing both two different clients and then splits up the payments. And there is something there. I don't know what it is, but it just doesn't sound kosher. And I definitely know that he can ask for his files or his information in any type of form. If it's email, if he wants to visit the office, if he wants to sit down, if he wants to have it in a CD, a PDF, whatever, he can have it however he wants it, as long as it's easily accessible and easily formatted by the city agency. That is his right under Sunshine. Thank you. That's it.
Thank you. Next speaker. Last call for public comment. Okay, public comment is closed. Any last thoughts on this motion, members? Yes.
This is Member Forsley. I'm just want to clarify that I'm not directly saying that COVID is the reason, obviously, but I do want to. I'm still learning up, and so is this type of censure like symbolic? Like, what are the ramifications if the person is found in violation of not attending a meeting?
Well, it's a very good question because the task force has limited enforcement ability. So in this respect, it is it's not so much symbolic as it is an actual violation. It's just the task force cannot act on it as far as creating some additional enforcement. What it does do, though, if it becomes a regular occurrence that a respondent, the same respondent, continues not to appear, then it can be considered a willful failure to comply with the ordinance. And there's any number of places in the ordinance that allows the task force to make referrals to either the Ethics Commission for a 6734 willful failure, or just on standard non-compliance of the ordinance to the Attorney General's office, to the DA's office, or to any other administrative office it deems that it wants to, we want to send it to. That's the limits. I hope that answers your question.
Thank you.
Anything else? Shall we be ready for a vote? Seeing no objections, please call the roll.
Chair Wolf,
Aye.
Chair Wolf, aye. Member Yankee,
Aye.
Member Yankee, aye. Member Frazier,
Aye.
Member Frazier, aye. Member Padmanabhan,
Aye.
Member Padmanabhan, aye. Member Neighbors,
Aye.
Member Neighbors, aye. Member Stein, Member Stein,
Mute.
Sorry, aye.
okay. Member Forsley,
Aye.
Member Forsley, aye. Member Schmidt,
Aye.
Member Schmidt, aye. Member Wong,
Aye.
Member Wong, aye. Member LaHood, oh, not present. Member Highland,
Aye.
Member Highland, aye. The motion for a violation of 6721E for not sending a representative to the hearing passes.
Can you give the tally, please?
Yes, it's 11 in favor of the motion with
It can't be 11.
10 in favor of the motion, including the absence of Member LaHood.
Okay, thank you. Okay, thank you very much. Let's call the next item.
Item number 6, file number 20062, complaint filed by Patrick Monette Shaw against the City Attorney's Office for allegedly violating Administrative Code Section 6721 by failing to respond to a records request in a timely and or complete manner.
Okay, members, I included this on the agenda just so we can have the, because the petitioner was available, and considering this item was somewhat missed as far as getting agendized at a committee. We're going to do the full vote here. We're going to first find determination of whether the records are public and if it's within our jurisdiction. And then once we do that, we'll head into, we'll make a motion on that, and then that will give us essentially a permission to move on to hearing of the complaint. So in this sense, we will hear 5 minutes from both parties. At that time, we would ask any questions with regards to the nature of the records with regards to whether they are public or not, and also determine among ourselves whether the item is within our jurisdiction, the request or the complaint is within our jurisdiction, and then we'll hear any rebuttals for 3 minutes, and then we will make a determination after that. And actually, I probably could pass the gavel to Member Schmidt, who is the complaint committee chair, if he so wishes. He wants to run the show.
Oh, please, you go ahead. Go ahead.
Okay. Thank you. Okay, so do we have both parties here?
I'm Patrick Monette Shaw. I am here, but I would like clarification. You're bifurcating this into a complaint committee hearing for 5 minutes. Do I get a second 5-minute period then when you move into the next phase of this hearing?
Yes, we will. And we're not acting as the complaint committee. We're basically hearing it as the task force. We're going to do the jurisdiction part as the full task force.
Okay,
yes,
so I either get 2 5-minute periods, or at least I get a 5-minute period and a 3-minute period, right?
No, it'll be the same periods of time as if you had a regular committee hearing. You got 5 minutes to make your presentation, and then 3 minutes for rebuttals. We'll make a determination on jurisdiction. If we find in your favor, Then we'll move into the regular hearing process. And you'll have another 5 minutes to make your case. This is just, the jurisdiction is just to find if the records you are requested, whether they are public or not. Simply as that.
Okay, so I think I can live with getting 2 5-minute periods and 2 3-minute periods, although I promise you I'm going to do my damnedest not to take, 16 minutes on this.
Okay, great. So we don't waste any more time. Let's begin this process. Ms. Leger, if you're ready with the clock. Mr. Shaw seems to be ready. Monette Shaw.
Go ahead, Mr. Shaw.
All right, thank you so much. I will try to be brief. In this first 5-minute period, let me just review the timeline. And before I do that, let me say my case that you just heard, which I'm disappointed that you didn't rule explicitly, although I'm hoping you put it in the order of determination, telling the city attorney's office they cannot take 2 bites out of the apple. They either get 1 10-day extension or they get 1 14-day extension, but they can't take 2 bites out of the same apple. So please put that in order of determination. On this case, this is not about lawsuits filed by city employees and the amounts of their settlement awards and the time and expenses involved by city attorney staff. Instead, this involves a case where the state of California fined the city and county of San Francisco $100,000. So there's a slight difference in the type of lawsuits, but obviously the entire issue is a public record. Let me say, even before the San Francisco Health Commission approved on September 13th, 2019, that it would approve paying the $100,000 fine to the state of California. Even before that, the Department of Public Health and the Health Commission had submitted a proposed ordinance suggesting language to the Board of Supervisors on actually approving the settlement. At that point, the lawsuit had moved into an active settlement phase, regardless of the spin control coming out of John Coate in the city attorney's office. By the way, for new task force members, you should be prepared that John Coate is the master of spin control as a media professional. On October 29th, 2019, the full Board of Supes passed the proposed ordinance that the Health Commission had proposed on first reading. And a week later, the Board of Supervisors passed the ordinance on the required second reading on November 5th. On November 12th, I submitted a request for the public records to the CAO in requesting the city attorney's time and expenses involved in fighting the $100,000 fine. On November 14th, 2 days later, the city attorney's office claimed the lawsuit was still open and could not provide the requested records. On November 15th, the mayor signed the ordinance the Board of Supes had passed on second reading, and the mayor's signature should have reaffirmed that the lawsuit was in fact settled and closed. On December 5th, the CAO continued to claim the lawsuit was still not closed, despite the fact that the mayor had signed into law the Board of Supervisors ordinance agreeing to pay the $100,000 fine. When I continued following up with the city attorney's office, about whether the matter had been officially closed. The CAO continued to wrongly claim on January 2nd and February 19th that the case was still not settled and was an open case. On February 28th, the city controller's office verified the $100,000 fine payment
30 seconds, sir.
had not been completed but was still in quote-unquote active processing. A reasonable person would assume that it could not possibly have been in quote-unquote active payment processing unless it was essentially a closed lawsuit. On March 3rd, the city controller confirmed the $100,000 fine check.
Sir, your time is up.
Would be mailed to the state of California on March 5th. That's my opening presentation.
Thank you. Respondent. The respondent from the city attorney's office. And Mr. Monette Shaw, if you could mute your phone by pressing *6, we would appreciate it.
All right.
Those sirens get pretty loud. Respondent, anybody from the city attorney's office? Representative from the city attorney's office? Okay, hearing none. Members, any questions or clarifications from either parties present? And this is just on the matter of whether the records being public and within our jurisdiction. Okay, hearing none. Oh, yes.
I
Member
have
Stein.
a minor question. Oh, I'm not muted. So what was the year that you originally requested it in November? For Mr. Shaw? He's still there?
Sorry,
Sorry, what was the date and year that you originally requested the information?
Sorry, you didn't tell me to unmute myself. So to answer your question, it was, I believe, November 14th. November 12th, 2019.
Okay.
I placed the initial request for the public records.
Yeah, thank you.
Member Highland, I thought I saw your hand up. Do you still have something you want to say in this? No. Okay. Great. Okay. If we're ready for any rebuttals, let's do that and move on with the process. Is the respondent here? One last call for the respondent. Hearing no. Okay. Mr. Monette Shaw, you have 3 minutes for a rebuttal if you so wish.
Okay, so I'm not actually rebutting the missing testimony from another absence of the city attorney's office, whether it's COVID related or not. They could have put Elizabeth Coolbrith on the phone, but I want to stress that John Coate is throwing sand in the eyes of the bull, or throwing sand in the eyes of the task force. This is not about whether it was an open case. It was closed when the mayor signed the legislation by the Board of Supervisors, regardless of whatever contrived closeout procedure that John Coate claims you have no jurisdiction to deal with. But let me address that in a little bit more granular detail in my next 5 minutes. And thank you.
Okay, thank you. Okay, members, the item is now with you. This would be to either find in favor or to oppose whether these records are public or not and within our jurisdiction. Is there a motion? Member Highland?
Yeah, motion to find jurisdiction and that these records are public.
Is there a second?
I'll second that.
Moved by Member Highland, second by Vice Chair Yankee. Any other discussion on the motion? Hearing none, let's open it for public comment. Public comment on the motion, specifically on whether on these records be deemed public and within our jurisdiction.
Yes, anonymous, please. Let me know if, when I may begin.
Sorry, Anonymous, I was on mute. I will start your time again.
No worries. Thank you. So I think, I guess I don't really hear these kinds of motions at the full task force, so maybe I missed why, I guess, it didn't happen at committee. I didn't really understand that. But I think what's important here is there might be a dispute about whether or not some of these records are disclosable public records, as in whether or not they're exempt under the CPRA. But I think there should be no question whether they are public records, because as long as they're about the conduct of public business and prepared, owned, used, or retained by the government, nothing else matters. And sometimes there's a confusing argument from the city that, you know, oh, well, this is a personnel record, or it's about a medical issue. Those are still public records. They're just exempt under all sorts of different exemptions, including, say, attorney-client privilege or attorney work product privilege, what have you. So I guess I've never made this kind of comment because I've just never heard this happen before the full task force. But I think you should vote in favor of this motion. Thank you.
Any other public comment?
Yes. Yes, can you hear me?
Yep, just a second. Go ahead, Mr. Warfield.
This is Peter Warfield, Executive Director of Library Users Association. You can be reached at libraryusers2004@yahoo.com or by mail at P.O. Box 170544, San Francisco, California, 94117-0544. I think that the Anonymous makes a very good point. And it's absolutely important to recognize the distinction between whether something is a public record or not, and whether it is disclosable or in part disclosable, or in part redactable, or entirely non-disclosable. I just wanted to say that when he said that there may be a valid argument when the city attorney or anybody else blurs the distinction between those two categories, that the records may be non-disclosable. Well, of course, I'm sure that he meant to say also that they might be disclosable. Their argument might be wrong on both counts, both as to whether it's a public record and whether things are non-disclosable or redactable or excludable. But it is worthwhile to make note of the different categories of evaluation of status, public or not public, and disclosable, not disclosable, partially disclosable through redaction, and so on. Thanks very much.
Any other public comment? Okay, public comment is closed. Are we ready for a vote? Hearing no objection, please call the roll.
Member Highland? Member Highland?
Did we lose him? There he is.
There he is. Member Highland?
Aye.
Member Highland, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye. Sorry.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member LaHood, absent. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find jurisdiction in the records of public passes.
Okay, thank you. Let's quickly move into the next part of this. It's the same item. We don't need to repeat the case description. Let's move into our opening testimony from each party. Do we have both parties here? Mr. Manette Shaw and City Attorney.
Manette Shaw, I haven't gone anywhere. I'm still here.
Okay, great. Is there a representative from the City Attorney's office? Okay, please note the record, there's no response. Okay, let's start with Mr. Manette Shaw. You have 5 minutes for your opening testimony.
Okay, thank you. I'll try to make this brief again. While I appreciate the public comment support from Mr. Warfield and the apparently male anonymous speaker, I do want to just allay their concerns. These records are not in any way confidential. It's not about patient privacy stuff. There are no privacy issues whatsoever. They are public records because they involve only the amount of time, the city attorney time and expenses involved in stupidly objecting to having to pay that fine, that even the mayor signed off on paying the fine. End of story. It's not debatable whether they're public records or not, since it involves only the amount of time a city employee or multiple city employees stupidly spent trying to stop having to pay the fine. Let me conclude my timeline of what the delay was from the city attorney when he kept claiming that it was still an open legal matter. It was not. And this is what I was referring to earlier, in that the city attorney will attempt over and over to throw sand in the eyes of the bull and throw sand in the eyes of the task force. John Coate kept creatively claiming, with his spin-controlled journalism background, that it was an open case. It was not an open and active or ongoing case involving litigation. And in fact, the LA lawsuit that John Coate creatively pulled out, he didn't tell you the full story of how the California Supreme Court, including Justice Chen, Justice Liu, and Justice Kruger, ruled. The 3 judges ruled unanimously concurring that withholding any release of the city attorney's time and expenses is only justified when there is active and ongoing litigation. At the point I requested the records, at the point the Health Commission, the Department of Public Health, the Board of Supervisors, and the mayor signed off on the Board of Supervisors' adoption of paying the frickin' fine, there was no ongoing litigation. Cote creatively tries to twist whether litigation was still ongoing to claim that it was still an open case and that you, as a task force, have no business interfering with whatever roadblocks the city attorney throws up in setting its internal processes for completely closing out a case. It's not about closing out a case after litigation had concluded. The point is, if there is no further ongoing litigation, the city attorney is required to cough up that information regardless of their made-up processes for officially closing a case. The city controller had agreed to pay the fine. The controller would not have agreed to pay the fine, nor
30
would
seconds,
the
sir.
Nor would the mayor have approved paying the fine if there was still ongoing litigation to give the city attorney cover to not provide me with the information on a timely basis. John Cote is snowing you, period. Thank you.
Thank
Other
you.
comments?
Any persons or witnesses provide any facts or evidence on behalf of the petitioner, the complainant?
Well.
Okay, hearing none. Respondent. They're a respondent. We already noted that there was no response from respondent. Okay, hearing no response from respondent. Are there any persons or witnesses providing facts or evidence on behalf of the respondent? Hearing none. Okay, members, this is question and answer, clarification, period. Let's try to keep this to about 10 minutes. Yeah, Member Stein.
Sorry to ask another very specific date question, but Mr. Moneta, what was the date that you actually got the information you had requested?
Let me walk back over. I have you on my handheld phone that I have on speakerphone, but I'm having to walk back over to my stack of notes on my gorgeous new desk. Can you ask your question again, please?
Yeah, I'm just asking what, I understand that you first requested the information November 12th. What was the date that you actually received the information?
I'm going to have to wing it, but let me say that when I'm pretty sure that my complaint, which I'm searching for, oh, there's the second one. When the city controller told me that the payment was scheduled to be mailed on March 5th, 2020, that is the day that Mr. Cote got off his high horse and provided me the records that I had initially sought. There's your answer. March 5th, 2020.
Okay, thank you.
Any other? Yeah, Member Schmidt.
Do you know what the date that, what was the date the case was dismissed at the court?
You know, when I got the amount of time and expenses that damn near came close to the $100,000 fine, that
do you know the date
wait a minute,
the case was dismissed at the court?
I'm trying to answer you that when Herrera's staff unnecessarily extended the lawsuit and attempted to get out of that fine running up city attorney time and expenses, and they finally gave me that the city attorney expenses almost equaled the amount of the fine. I lost interest in this, sir, and I didn't go back and find out when the Superior Court dismissed the case. That is not the relevant issue.
So you don't know?
No, I don't know, and frankly, I don't get.
It was after March 5th, correct?
No, I can't say correct. You're not going to force me into a corner. I have no idea when they did it.
Okay. But it was still active when you got the information that you did get from the city attorney's office, or it was. It's unclear from what you've told us why you think the case was not an active case.
Well, you would have to ask Mr. Cote if there had been any additional ongoing litigation, not the issue of whether it was open or closed by the city attorney's made-up processes, but litigation had effectively ended. There was no other litigation involved after I had made my request. And in fact, the Supreme Court of California said, you know, if you're not involved in ongoing litigation, you may not withhold the records.
Well, you were just...
Unless John Cote can show you and prove to you in his absence tonight that litigation continued and was ongoing, they had no basis to withhold it. If litigation had concluded to the point where the mayor signed off on paying the fine because litigation was done.
Now, wasn't the settlement agreement signed in February of 2020?
I
They
don't
didn't even
know.
settle it until then, right? That's what the file indicates. You don't know? Okay. I don't know any further
I would
questions.
have to look at the minutes of the Health Commission meeting to look back at what date the signatures had happened at the Health Commission. And since the Board of Supervisors had approved the settlement on November 5th, I'm assuming November 5th came before the date that you just mentioned, right?
Yes.
There's your answer.
Well,
and I'm assuming, wait a minute, and I'm assuming that the Board of Supervisors would not have signed off on November 5th, and the mayor would not have signed off 10 days later on November 15th. If litigation was still going on, they would not have prematurely signed an agreement if they expected litigation to be continuing. And since the Supreme Court said you can only withhold this information if you expect litigation will be ongoing, the Board of Soup signed off saying, you know, we don't think litigation is going to come up again. The mayor signed into law the Board of Supervisors ordinance. The mayor must have assumed, you know, there's no more litigation that will be ongoing. So, ergo, the case is closed. No matter how creatively John Cote wants to spin whether it was an open, active case in the absence of ongoing litigation that wasn't happening any further.
But how do you explain the document in the file, which is titled a settlement agreement, which is dated February 2020, and there was no settlement agreement before that, which is evidenced by the fact that that's the date that they actually put their signatures on an agreement. How does that work with these dates that you're talking about in November and October?
Well, I'm assuming you said the settlement agreement was signed on the 20th of November?
No, February 2020.
I'm sorry. If the settlement agreement was signed on February 2020, John Coate had no business telling me on March 3rd that the case was still open, right? You can't tell me a case is open if...
That's fine.
Yeah.
I have no further questions.
Okay, Vice Chair Yankee.
Yes, I just wanted
They're
for
both waiting to come back in, weren't they?
Yes, they were.
just for the members following along. We were on page. We're being referred to as on page 110. But I kind of don't have to say with Member Schmidt already covered it. Although I'm hearing a lot of background noise from someone here.
Hold on. Victor, can you please mute yourself? Thank you. Go ahead, Member Yankee.
I was going to say just that the settlement agreement for the other members, the signatures are on page 110 or P110 at the bottom. But the questions I had were pretty much already covered by Member Schmidt, so that's all I had.
Okay. Any other questions, clarification of the parties? Okay, let's move to rebuttals. 3 minutes. We noted that the respondent is not present. We'll move straight to the petitioner. Do you have 3 minutes for any rebuttal?
Okay, I'm going to make this is Patrick Manetchal. Can you hear me?
Yes.
We can.
Okay, so I didn't understand respectfully the question that came out of left field from one of the task force members. If the settlement agreement on page 110 was signed on February 20th or whatever in 2020, John Coate had no business telling me several days or a week later in March that the case was still open. This seems shut and dried to me that at the point the settlement agreement was signed and the city controller was actively cutting a check to pay it and mail it on March 5th, John Coate was lying to me when he told me 2 or 3 days earlier that it was still an open case. So respectfully, you should reject the rebuttal that John Coate provided to you just 5 days ago on January 28th, which I had never seen until you guys published the SOTF agenda for today. And then I saw belatedly and had no opportunity to write a written rebuttal to his response dated January 28th, where he told you, you know, task force, you got no jurisdiction over our internal processes, and then he didn't show up for today's hearing. As if he knew, because I know, he's got no leg to stand on this case. Thank you.
Thank you. Okay, members, the item is with you for deliberation and a motion. Member Stein. You're on mute, ma'am.
Hi, sorry. So I just wanted to say how I'm looking at this right now and see if anybody else on the task force can sort of enlighten me on some things. But it seems to me that there's no question that this is public information, because when you look at the Sunshine Ordinance, it talks about litigation material, unless otherwise privileged, when litigation is finally adjudicated or otherwise settled, is public information. And then, of course, financial information and budgets are also, a really high category of privileged public information under the Sunshine Act. But what seems to be at issue here is, when is that public information no longer exempt, right? And it has to be when the case is finally, in terms of litigation, it has to be when the case is finally adjudicated or otherwise settled. And it does seem like this settlement, even though it was a proposed settlement that had to be approved by the mayor and by the Board of Supervisors and all of that, it wasn't actually approved until February 3rd, 2020, at which point the plaintiff had 30 days to file for a dismissal of the lawsuit, which I guess would be, when it's completely finished, right, and closed and adjudicated. Are there any, lawyers here who can comment on if that is correct?
I Member Schmidt here.
Yeah.
That's pretty much the way I'm looking at it, the way you just laid it out. And I think all those are important dates to consider here. I'm guessing that they probably cut the check right around March 4th, March 5th, and they probably filed a dismissal sometime in March. I'm guessing.
They would have had a month from February 3rd to file for a dismissal, right?
Yeah. And so the case would have been, technically it's on file. I think that the signing of the settlement agreement is a pretty significant aspect of what goes on here, because it's hard to go back after that. But up until you get to that point, there's still some variables. And so they may not be doing things like, depositions, document discovery, but anyone can back out before you actually get those signatures on a settlement agreement.
Yeah, I mean, the only other thing, that's how I read it in terms of timeline. The only other thing that kind of weighs with me is that, the petitioner is just asking for a kind of blanket amount that was spent, right? And I don't think that violates or that poses any danger to the litigation necessarily, because you can't really tell anything detailed about that, about strategies in the case or anything like that. It's just a kind of blanket amount that was spent to date. So I just kind of want to throw that in there, because I'm not sure that would be as highly privileged as material that should be exempt as something that would actually reveal, strategies in the case and all of that.
Vice Chair Yankee. No.
Thank you.
Vice Chair Yankee. And please keep the commentary down. Thank you.
Okay, yeah. My thinking is very along the same lines as Member Stein and Member Schmidt. Working with, in county government myself and kind of going through how some of these cases go sometimes, you'll see things go to the board for an authorization to settle before the settlement actually takes place. What that's basically doing is an action taken by the board that authorizes the council or whomever the parties are to start engaging in the settlement agreement. It's not as if there was a written settlement agreement that went to the board in November, right? That's just an authorization for the settlement process to begin. So for me, the important date to start with to look at is the February date when the last signature was on the settlement agreement. And so I guess for me, the biggest question then is, when is it considered finally settled? Is it when the last signature is on that settlement agreement, or is there a period of review by the court before they finally say, this case is now closed and it's settled? I'm not a lawyer, so I don't know that. So maybe that's something either Member Schmidt or DCA Mark Price Wolf could speak to about when does the court have to review the settlement agreement after the last signature is on it. So I'm kind of looking at that time period between, I think it was February 3rd was the last signature, and we're hearing March 5th-ish, I think it was, is when the information was released. And so is there any official action by the court in that time period? So
I can speak to how that works.
Okay, that'd be great. Thanks.
Yeah, it's pretty administrative stuff. The court actually, in this kind of case, doesn't have any role in, like looking at the substance of a settlement agreement. Basically, the parties, they get together, they execute their settlement agreement, and then they make a deal whereby somebody's going to file a final dismissal paper with the court. And the court doesn't do anything. They never look at the settlement agreement. They probably never did in this case. All the court does is they just wait until a dismissal gets filed, and then the case is over. So from the court's perspective, no, nothing else happens down at the courthouse.
So under, I'm looking at the CPRA, right? And there's an exemption for records pertaining to pending litigation, and then it says until the claim has finally been adjudicated or otherwise settled. So I think for me is we have to figure out what the date that this case was, quote, otherwise settled. So would that be the dates of the last signature on that document, or is there some other administrative action that would need to take place post those signatures until it is, considered officially settled?
Yeah, and my thought is the two possibilities that come to my mind are that one that you just pointed out, the date that the settlement agreement is signed, or possibly you could say the date that the dismissal's filed with the court, which would be probably about a month later in this situation. Those are the two that I see as, we could maybe go with one, maybe go with the other. And I don't know what to tell anyone as to which one to pick among those.
Yeah, the interesting thing is I think if it were the February date, right, then it would have been at least a month until these records got released. Whereas if it's the March date, it sounds like the records were released, very timely after that final action. So I think it kind of potentially does matter which of the two we look at, because I think there is one would make the records timely and one would not, and I'll drop it at that.
Okay, I've got Member Wong and then Member Stein, and then we want to kind of wrap this up and try to see if we can come to a decision. Member Wong.
Somebody please ask me a question.
Hi, this is Member Wong. So something I wanted to point out was on P92 of the PDF for page 18, we did get actually a written response from the respondent, and it does state that on March 5th, after the closing process had ended, we released the data to the complainant. And so it's difficult because the respondent is not here to know what this closing process is, but they do refer to each of the dates that the complainant reached out to them and that they responded every time to say, it's still in process, we will get back to you. But that being said, I want to know what the closing process is, but they do state that there was one up until March 5th.
Okay, Member Stein, and then I think it would be helpful if we had our legal counsel chime in. Maybe they have some additional information on that. Member Stein.
How about an additional question?
Please, Mr. Minette-Shaw, you're interrupting the meeting, and please hold off your comments. Thank you.
Yeah, I mean, the timeline is one issue, but then I guess I'm looking for clarification on this exemption for litigation, because it seems like in the court cases that are out there that it has to do with, attorney-client privilege or the work product of the lawyers, but neither of those things is really at play here, because, we're just looking at a budget number that isn't even implicated by a time frame, right? It's not like we see the city spent this much at this month and this much the next month. So really, there's no, is it a blanket exemption for any litigation, or is it only if there's a danger to the, attorney-client privilege or to the work product that's, part of that?
Are you asking a question?
Yeah, I guess I'm asking if anyone has a perspective on that, because,
okay. I'm going to ask our legal counsel to chime in on that question and on the question about closeout procedures. DCA Price Wolf, are you available?
Yeah, can you guys hear me?
Yes, go ahead.
So a couple thoughts on that. I think the concept of pending litigation is not always so clear, and I think you guys are really dancing around the right facts here. And so I was taking a look at the settlement agreement itself, and not just the signing date, but sometimes agreements have actions within them that happen after the signatures, which would suggest the matter isn't closed until certain conditions are satisfied, or there might be additional acts. And Member Schmidt was sort of getting at that with other acts that maybe attorneys or need to happen in court. One such thing in the agreement says that within 30 days of signing of this agreement, the plaintiff must dismiss. So I think you have to take a close look at the actual settlement agreement to see if there's any further action in there, because just because there are signatures on a settlement agreement, that doesn't mean that the case itself is over, right? Other things might need to happen that would still make the conflict still pending. So that's one piece of advice I give you, is just take a close look at the settlement agreement and see if there are other things in there that would suggest that the matter is still pending. Do other things still need to happen in order to resolve the case? Or is the settlement the end all be all of it? So that's one thing. The other thing, I think it was Member Stein. I apologize if I'm getting your last name wrong.
That's correct.
Okay, that was just asking those great questions about is pending litigation a blanket exception to any sort of request? To an exception to turning over records. And you're asking or is it just items that might be attorney-client privilege protected within pending litigation?
Mm-hmm.
I think it's a great question because it's important, because they're two different inquiries. So I think pending litigation is its own pretty broad exception to public records. Separate from that is attorney-client privilege. So in other words, it doesn't have to be a privileged document within pending litigation for the exception to apply, right? So
okay.
I think they're separate. And I agree, it's broad. It is broad. I think you are very accurate in that characterization.
Member Frazier.
Yeah, if our counsel's still on the line.
Yes, go ahead.
Yes. So they're claiming a work product privilege, which my understanding of that is typically that's documentation prepared for litigation and in the course of preparing for litigation. And to get to Member Stein's point, it doesn't appear as though this number has anything to do with actually preparing for closing out or preparing for litigation. If it's just a number tallying resources, I don't think that's some notes on strategy for how they're going to close out, or something that would blatantly be work product privilege.
So that's another great question. So work product privilege isn't just about litigation. It's about any sort of work product that's either done by or directed by an attorney or an agent of an attorney. So it doesn't have to just be an active or pending case in order for the work product to arise. And I mean, you bring up good questions. I think those are good questions maybe for one of the parties, right? Well, can you talk in more detail about what this covers? So
let me ask you a question, DC Price Wolf.
Sure.
This isn't a private law firm. This is a government department. And doesn't the public have a right to know how much it's spending?
So I feel like it's a bit of a rhetorical question. I don't know if you're asking me a legal question or
No,
you're kind of getting at some policy issues.
No, it's a serious
right. So
question.
I think I'm not.
They have.
I think you mean to direct that to a rep. Or sorry, go on.
Any department that's is being appropriated taxpayer money has a responsibility to report out how they're spending it. So here the question, the requester, who's a member of the public, is asking how much money was spent on this case, and is asking for a whole number, not for a detail, not asking for billing documents and the like.
Mm-hmm. Can you restate that your actual specific question, legal question?
The question is, does the city attorney's office, being a public office supported with taxpayer funds, required to report on its expenditures? And wouldn't this be considered one of those expenditures? It's not a private law firm.
So there are a couple of loaded things in there, like taking away whether it is or isn't a law firm. I think there are certain aspects that it's certainly the amount of money in the budget and expenditures are a matter of public record, just as any department, agency of the city would have to disclose that. Sure.
Okay, Member Wong.
Oh yeah, another thing that I wanted to point out too, because everyone keeps talking about a lump sum and money, but another thing that was requested were the time, like the man hours or person hours that were created out of this entire lawsuit. So that does speak to some level of work product, because it is the hours that each of the attorneys worked. So something else to consider as well.
I would say on the respondent's response on page 92, 92 of the packet, page 18 of the PDF, in number 2, that very first paragraph, they cite Los Angeles County Board of Supervisors versus Superior Court, in that attorney-client and work product privileges that's attached to billing information is privileged.
For ongoing litigation only.
Yeah. Can I
Go
ask?
ahead, Member Stein.
Yeah, I actually went and read that case because they cited it, and it's not that straightforward, because it is talking about ongoing litigation, and it's talking specifically about the bills that the law firm bills, and links it to, if you see that they spent more money this month and less money that month, you could potentially link it up to strategies in a case and activity in a case. But it's quite very questionable to me that it would apply in this instance, that particular ruling, because they talk about it as active litigation and a kind of granular billing, looking at the bill itself. And the petitioner here is not asking to look at the bill and see a month-by-month flow of what was spent each month. They're just asking for something cumulative at the end, and I don't think it would rise to the conditions of that case and be applicable.
Okay. Any last items? Otherwise, I'm going to ask for a motion.
Yeah.
We've got 2 items to consider here. One is the time factor as to when the litigation ended, so that the information could be made public, and 2, the records requested, whether they are disclosable or not, and shall we order them to be disclosed? Yes, Vice Chair Yankee.
Just real briefly, my understanding is that the records were disclosed. So I don't think that there's any records that remain undisclosed. I think it was just when they were disclosed. It's the question before us.
Okay. Well, I'm mistaken. I was just considering what we had just been discussing. That's all.
Okay.
Okay. So then it's on the matter of the time factor. Or motion. It's okay to get it on the floor so we can have a deliberation about it.
Okay, I'll make a motion just to get it on the floor, just for some discussion. I'm going to move that we find no violation, and the reason for that is the signatures weren't until February 3rd. It seems like there's 30 days afterwards to file certain paperwork with the courts, which would bring it to just about March 5th, which is when the records were disclosed. So as a starting point for the discussion, I'll move for no violation.
This is Member Wong. I'll second that.
Okay, moved by Member Yankee, second by Member Wong. Any more discussion before we open it up to public comment? Yeah, Member Stein.
I'll just say very briefly that this is like the last case. I'm not happy that there's not someone here to ask questions that I think are very germane to understanding, what the details of their arguments would have been about these issues of whether it really is work product, whether it's really, something that implicates attorney-client privileges or should be protected, should be exempt, and why they choose the timeline they do.
Okay. Member Yankee, I think it would be helpful, or Vice Chair Yankee, it'd be helpful to notate that we're finding no violation with regards to what?
Timeliness.
On what section of the ordinance?
What would that have been? I think hang on one sec here. I'm trying to actually find the original. So there was under 6721, which is what the initial complaint alleged.
No subsection?
There wasn't one noted. We could put, if we want, we could put B, 6721B.
Okay.
Which is the one that talks about disclosing it within 10 days. So I'll say no violation for 6721B for timeliness.
Okay, great. Okay, Member Stein, you had your hand raised. I just lowered it.
Sorry, no, I didn't mean to have it raised.
Okay. Any other discussion on this before I open up public comment? Okay, let's open it up for public comment. Mr. Leger, are you ready?
Anonymous. Please let me know if I may speak.
Go right ahead.
Thank you. I think that this is actually a very close question, but I think there's an obvious violation that has nothing to do with the timeliness. In addition to the fact that it didn't show up, which is a 6721E violation, but I believe there is a 6727 violation. Can someone please mute? I believe there is a 6727 violation on page P85, where they cited the attorney work product privilege, and they say until the matter is closed. But that's impossible, because work product privilege is, my non-lawyer understanding, always work product privilege, and has no bearing on whether or not the matter is closed. The correct citation, if one is applicable at all, is attorney-client privilege, as is stated in Los Angeles County Board of Supervisors, the case that they cited in their full written argument to you. And they've done this in the past. They'll give like an approximate justification, and then when you bring an SOTF complaint, then they actually do the legal research to find out which the real justification is. So it's possible, depending on how you determine on that date issue, that it was actually attorney-client privilege at the time it was requested. But I would agree with one of your members who said the billing information is not attorney work product privilege. It could have either been attorney-client privilege or pending litigation material, which is also a state exemption. But on the pending litigation material, that is severely limited by local law, that exemption. But the attorney-client privilege cannot be limited by local law. And so my view on this is, I don't know whether there's a timeliness violation, but there's definitely a written justification violation, because they may have corrected the justification to you, but the justification they gave in writing on P85, I don't think is correct. That until the matter is closed, the requested information is exempt as attorney work product. No, it's either pending litigation material as limited by local law in 6724, or it's attorney-client privilege due to the ruling in Los Angeles County Board of Supervisors. Thank you.
Next speaker.
Somebody
Yes,
on the
it's
list?
Dentist Tedessa.
We hear you, Mr. Tedessa. Just a moment, please.
Hi, just a note for the record. I've been having trouble calling in. All the times I call in, there's something that has the ability to knock you out of the phone call, and then when you call back in, you try to get into the meeting. You press the right code in, and then it gets you into the meeting. But then it either, if it's muting you, then it won't let you unmute yourself. I just want you to know that that's happening a lot. I mean, it's happening to me. And just for the record, please don't use this for the time that I want to speak about public comment. Regarding the public comment, the timeliness thing, I see what the city attorney actually is saying, but the Sunshine Ordinance has a provision that says that it should take all these complaints that are coming from complainants and look at it as at the most favorable light. And since the city attorney is not present there, you should find in favor of whatever the complainant is asking for. The city attorney is not there to give you responses to why and all the details that you need to come to a conclusion to this matter. So you should, by de facto, you should rule in his favor. Again, with this case, regarding the regarding even how the case is handled, when you first introduce the case, you're finding jurisdiction. The complainant was allowed 5 minutes to actually present his case. In my case, on June of 2019, I wasn't able to even provide that to you. You just went into the deliberations, and then I had to work my way back to the point of me even explaining why I was there in front of you. Again, this is one of the reasons I'm asking, please, members, look into this situation of 18010 and 18028, and please get back to me. I would hate to file complaints against the Sunshine Task Force for not following the complaint procedure and for not following the 45 day late rule. And that's it. Thank you.
Next speaker.
Yeah, I'm on the list.
Go ahead, Mr. Warfield.
Good evening. It's Peter Warfield. Excuse me, Executive Director of Library Users Association. Certainly, I'd like to agree with most, if not all, of what the previous members of the public have said, including in particular the violation of 67.21E, which you found in the previous case already, and which I certainly think you should find a violation on. And the issue of taking things in the most favorable light to the complainant, which the immediate preceding speaker spoke about. I'm sorry to say we are not making further judgments. We're not a party to the case and are not familiar other than having heard the discussion. So I want to say something about money, billing, versus the substance of a case or the substance of the advice of an attorney. Library Users Association was very concerned about the expense that the city attorney was spending to advise the library in a previous matter with regard to legal advice on privacy issues concerned with the installation of software that the library was using for the public. And as I recall, we were given, and when we asked, we were giving a variety of billing information, including things like I believe it was monthly, but the city attorney had hours billed in a kind of a spreadsheet so that you could see the level of billing, possibly the name of the person giving the advice, and the amounts billed per hour. And that was just basically money. That wasn't advice, that wasn't strategy. And I believe we ended up as well with memos that were sent where pretty much everything was redacted except the fact that the city was giving advice on that particular issue as opposed to other issues related to the library. So I think that money is a completely different story, excuse me, and could even be requested during the process of advice being given or a trial. Because
20 seconds.
You're not asking for the content of what's being told or what's being litigated. You're just asking for the money, and that's not a redactable amount in this case.
Your time is up, sir.
Next speaker. I was hearing no other public comment. Back to you, members. Any further discussion?
Just noting for the record that Member LaHood is present now.
Yes, that would be at 7:55. Yeah, Member Stein.
I just want to say, just kind of looking at the Sunshine Ordinance law and looking at the California Public Records law, it seems clear that there's this exception for litigation that's considered, that hasn't been finally adjudicated. And, so that kind of seems clear to me, but I feel like this was information that, could have discretionarily been released because it doesn't really implicate the things that were given as defenses for not giving the information out.
Okay. All right. Thank you. If there isn't anything else, we're ready for a vote. Hearing no objections, please call the roll.
Wait, repeat the motion, please.
The motion is to find no violation of 6721B. As the signature was not made until February 3rd, and then there is a 30-day period which would have made it around March 5th when the records were provided. Okay, call the roll.
Member Yankee?
Aye.
Member Yankee, aye. Member Wong?
Aye.
Member Wong, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood, you voting on this?
I don't think I should since I just came back.
Okay.
Well, then
I can step out.
Please
I'm stepping
step
out.
out. Step out. Thank you.
All right. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
No.
Chair Wolf, no.
Okay, the ayes have it. Are there any other motions? I would reiterate taking another motion to find a violation of 6721E for not providing a representative to attend the meeting.
I'll second that. This is Member Wong.
So moved by Chair Wolf, second by Member Wong. Any discussion? Any public comment? Okay, hearing no public comment. We
Hang
ready
on
for a
again.
vote?
What was that? Bruce, what was that citation again?
6721E for not providing a representative. Okay, we're ready for a vote.
Point of order. I think you want public comment on that.
Somebody's hungry.
Patrick is hungry.
He called for public comment.
Okay, is there going to be public comment on this
No,
motion?
I've already called public comment. Please call the roll, please. Thank you.
Okay, okay. Chair Wolf?
Aye.
Chair Wolf, aye. Member Wong?
Aye.
Member Wong, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Member Highland?
Aye.
Member Highland, aye. The motion to find a violation of 6721E for not providing a representative passes.
Okay, thank you. All right, at this time, I think much needed recess is in order. It is 8:01. We will return at 8:11, giving us 10 minutes to do what we need to and me to feed my fur babies.
Thank you, task force members, for thoughtfully considering both of my complaints.
Sure thing.
Enjoy your break.
Okay. Members, please put yourself on mute and you can turn your video off. When you return, please remember to turn your video back on. Thank you. Okay. All right, we all back together here. It's like everybody's filing in. All right. Cheryl, are you available? Ms. Leger? You're on mute if you're trying to talk. Cheryl, are you there? Oops. What's going on? She got bumped off. Waiting for her to come back on. And Victor's not here either. Trying to figure out who this guest is. All right, we're just waiting for one or the other administrators to come back in to the meeting. Oh, there's Cheryl. Cheryl, please unmute.
For some reason, I got a message on my computer that I was offline and all of you went blank. So I had to reconnect.
Okay.
That's what happened.
I don't see Victor here, but there is somebody logged in called guest, and it's not one of our members. And I'd like that. I don't know who that is or what that is. And I think they should.
Hey, Bruce.
Yes.
I'm wondering if it's my new colleague, Helen Castillo, who I'll introduce, because she has access to the Zoom. Maybe I'll text her and see if it's her. Maybe she
can just unmute.
Or she could just pop in and say hi.
Yeah.
*6. Otherwise, I also don't know who it is. I was going to introduce her during the orientation.
Well, she's logged into the into the Teams system, then.
Probably because she did get an invite. So.
Okay, so then.
It's better safe than sorry.
Yes, would appreciate that. Thank you.
I'll text her. Maybe she can't figure out how to unmute.
Okay. All right, Cheryl, are we back on the record?
It says we're recording.
Okay, great, perfect. Okay, so we'll resume our meeting now. We are now in our orientation. I want to start off by saying welcome and to all the new task force members and returning task force members. I want to apologize after the fact for not apologizing before the fact that I was throwing everybody into the gauntlet of having some of these cases, just so you can get kind of an experience of how things go. And we had a pretty good selection, very interesting stuff. I think everybody had some very good comments to make and good contributions. And so I think it's a good, for me, it was a good introduction. I don't know about you, but for me it was. I'll be selfish about that. So the way we're going to run this, I don't want, trying not to keep everybody here too late. We kind of want to run through a few things here and then talk about some special projects that we have started and are thinking about. I'm going to relax Robert's rules a little bit so we can just get this run through. A lot of it's just mostly going to be presentations and introductions. And for public comment, I would ask that if the public can keep their comments to all of items A through F. I would appreciate that. And then when we get to item G, we'll break each one down, public comment for each one of those since they're more substantive items. Okay, so again, I just want to thank everybody for their service in coming on to the Sunshine Ordinance Task Force. We really appreciate your stepping up for this. This is not a place where a lot of people like to come, so to speak, because it is somewhat demanding and engaging and demanding of your time. So, we meet like this once a month for the regular meetings. And in between that, we have various subcommittee meetings. We have 3 standing committees and 4 standing committees and 1 ad hoc committee that's pretty regular. And so you'll be required to come to this meeting once a month. We meet on the first Wednesday of every month. That's been the regular time. If it really is rubbing against your schedule, please contact me directly, and we'll see what we can figure out. It's only this day because when City Hall is open and we are regularly meeting in person, that's the day that room is available to us that we have reserved. So that's why we keep it on this day, because it also is familiar for the public and the city staff to kind of not schedule things during this time in case they're being asked to show up. Committee meetings are generally shorter. They meet sometimes a little later. They generally don't run more than a couple of hours. And it depends upon how big a backlog we have on complaints. So every one of our main standing committees can hear complaints beyond the complaint committee as an overflow, and that's beyond their regular charge. The charge of the complaint committee is complaints, so it has to hear complaints primarily. With that, we had an orientation back in December because we weren't sure when the appointments were going to come up here. Some of the items that we covered back then, we're probably going to review some of the same things anyway here. So I'm not going to rehash the items that we discussed before. I think we're just going to forge ahead and get on with our agenda here at this time. So, Cheryl, why don't you read just into the record item number 7?
Item number 7, Sunshine Ordinance Task Force Orientation. Robert's Rules of Order will be observed, but also relaxed. Subsection A, quick debrief of just previous orientation items. Subsection B, introductions, task force members, icebreakers. Subsection C, introductions, administrator and legal advisor. Subsection D, review of other officials and entities interaction. Subsection E, review of bylaws, complaint procedures, committees, and Robert's Rules of Order, and statement of incompatible activities. Subsection F, overview of Sunshine Ordinance, California Public Records Act, and Ralph M. Brown Act.
Okay, great. So in the spirit of calling roll, we're going to skip to item B, and I'll ask Cheryl if she can call by seat number, starting with number 1, for the first person to provide an introduction and just give a short brief about who you are and what your interest here, what brings you to the Sunshine Task Force.
Seat number 1, Dean Schmidt.
Great. I get to start. I'm fairly new. I've only been doing this since September. The seat I'm appointed to is, I was nominated by the Society of Professional Journalists as their attorney nominee for the task force. I'm a litigator. I've been doing it for about 30 years. I'm in San Francisco. I do a lot of different things, but this stuff I love doing as much as I can get. First Amendment stuff. It's really, really interesting stuff to me. And that's, I better just leave all the other stuff for later. That's me. Bye.
All right, seat number 2, Lila LaHood.
Hi, everyone. I'm Lila LaHood. It's nice to meet you all. I am in my second term on the task force, so I guess I'm about 2 2/3 years in. It's been a wonderful experience. I signed up for a second round. I'm currently the chair of the Compliance and Amendments Committee. When I'm not doing this, I'm the publisher of the San Francisco Public Press. I'm also a board member of the Society of Professional Journalists Northern California chapter, and I am SPJ NorCal's journalist representative for seat 2. I have gotten so much out of this experience. You know, I know we all make a big time commitment to do this, but I am grateful for having this experience and for what I've learned from my fellow task force members, from people who work with the city, and from members of the public who consistently bring amazing questions, and they are stress testing our system, and I love it. And I'm quite enthusiastic about this work, and I hope that if you aren't already, you will become enthusiastic as I am. Thank you.
Seat number 3, Kevin Frazier.
Hi all, great to be joining you. I really enjoyed that first portion and look forward to continuing to learn from you all and to continue to dive into these fascinating and extremely important issues. I'm currently in law school at Berkeley. I'm what law school students call a 2L. So I'm in my second year with 1 year to go. And I grew up in Oregon. My first job out of school was working as Governor Kate Brown's executive assistant. And for folks who aren't familiar with Oregon politics, she followed the resignation of a governor after a lot of lack of disclosure of information. So I was very much in a public policy and legal setting evaluating how to be more transparent. And since then, I've been very interested in helping the public stay informed and get access to the information that they need to keep folks accountable. So in seat 3, I'm the electronic media, I believe, representative. I've written hundreds of op-eds, including lots for the Chronicle, and have previously had columns in the Richmond Review and the Marina Times. So thanks, really excited to be here.
Seat number 4, Jaya Padmanabhan.
You're on mute.
Hi, everybody. I'm Jaya. I was also nominated by the Society of Professional Journalists, and I work part of the time for ethnic media services, and I think the whole process of journalism to a certain extent also is disseminating information to the public. And so I thought this would be a great way to learn more about the process. I also write a column for the Examiner and do a few other things. Got it.
Seat number 5, Jennifer Wong.
Hi everyone, I'm Jen. I am in seat 5, which is the League of Women Voters nominated seat. So I've actually participated in Sunshine Matters via the League of Women Voters, and also as a volunteer with an organization called San Franciscans for Sunshine. I just have a general interest in helping the public in several different ways through the League of Women Voters, including Sunshine. So that's essentially what brings me here. In my day job, I'm actually a software engineering manager, so essentially completely unrelated, but sometimes we'll build software that helps make those records available. That's it.
Seat number 6, Laura Stein.
Oh, good. That's my seat number. Okay. Hi, I'm Laura Stein. I am a former professor of communication where I specialized in communication law and policy and social movement communication and kind of small p political communication. And I spent my last several years in academia studying freedom of information, and I actually had a Fulbright to go to India and look at how freedom of information law was understood there, and I interviewed hundreds of people, both in government and without, about their experience of using the right to information law in India, and my entire career was really focused on issues of access to information and media. I wrote a book on the First Amendment that did pretty well. And I guess I would just say I saw this opportunity when I moved back to San Francisco, and I thought this was a great way to apply my expertise and kind of my lifelong interest in access to information to something that could, make an effect in the city I live in.
Seat number 7, Matthew Yankee.
Hi everyone, my name's Matt, and this is now my second term, so I'm happy about that. And before I served as chair of the Information Technology Subcommittee, which is pretty interesting. We did a lot of the metadata that dove into that, and I'm also serving now as the vice chair of this task force. I lived in San Francisco for about 10 years before I moved here. I lived in Michigan and was the director of elections of Washtenaw County, which is where University of Michigan in Ann Arbor is. It's kind of one of those jobs where no one really notices what you do until this past December, where everyone cares about what you do. So you can see kind of why, having elections be open and accessible to the public, and not just the elections, but how we, administer them on the back end and canvass things is so vitally important. So here I work for Alameda County. I've been there for about 10 years. I'm the chief of their clerk quarters office, and so we do a lot of records. Anytime you record deeds or your mortgages and so forth, if you want to get married, if you want your birth certificate, and so we're probably one of the most high traffic areas of county government that you'll find, which is interesting. And I love to boast about the fact that we have a 4.5 star Yelp rating, which for a government agency is actually pretty fantastic. So, I think that says a lot about, our mission to be accessible to everyone. So this task force is great. I think we learn a lot about how members of the public try to interact with government, and I think it shows that, it helps us hold government accountable and show that we're really there to be there for the people, answer their questions, and provide the information that they're looking for. I mean, we're there for them. So it's nice to meet all of you. Thank you.
Seat number 8, Chris Highland.
All right. Hi, everybody. This would be my 5th term serving on this task force, which I think makes me the longest consecutively serving member. And I've been the vice chair and the acting chair of this body in the past. I'll tell you all that when I came on board 8-9 years ago, we barely had a quorum. We had a huge backlog. But I'm really pleased to see so many people here, and we're going to get through that. The backlog we have now is nothing compared to what we have, and we have some creative ways. I think the chair and the vice chair are coming up to help us through that. The rest of the time, I'm a recruiter for the space industry for NASA projects, looking for rocket scientists and thermal engineers. That's what I do for my day job. And I have a 7-month-old boxer puppy who will be popping up on the screen from time to time, so don't be alarmed when you see him. He's a great advocate of sunshine and follows closely. That's it for me.
Seat number 9, Lori Jones Neighbors.
Hi, everybody. I'm so glad to be here tonight. It's exciting. I really enjoyed the work that we did together earlier. So I think this is just such a great start for me. I'm a researcher and evaluator, self-employed. I've been doing that here in San Francisco for about 10 years. Before that, I worked for an organization called Urban Habitat, which is one of the nation's oldest racial, economic, and environmental justice organizations, and founded the Boards and Commissions Leadership Institute there, which is designed to support low-income people and people of color in participating in boards and commissions. Been continuing that work around the country since I left Urban Habitat and started working on my own. And first came across Sunshine Ordinance when I was first starting out at Urban Habitat, just kind of wandering around looking for interesting commissions that low-income people and people of color might want to know about, and thought that Sunshine Commission was probably something to do with trees or density, and found out when I wandered in, not at all. And I've been kind of tracking the commission since then, hoping to get on. And there have been some seasons when I knew that my district supervisor would never put me on the commission. So it's been like finally a chance to get on the commission right now. I'm excited about that. Certainly transparency in government is pretty much the core of the work that I do, that and anti-oppression and systems change for institutionalized oppression. And I have a 13-week-old puppy, a miniature schnauzer. I think you might have seen his ears earlier when he wandered in by accident. He wasn't supposed to be in here, but his name is Grumble, and you'll see him too, I'm sure.
Seat number 10, Kai Forsley.
Hi, I'm Kai Forsley. It's pronounced Kai. You might have to ask me more than once. So I became interested in the task force about 10 years when I actually had to file a case with the task force. In my case, I like to say set the precedent for community benefit districts being subject to the Sunshine Ordinance. So I don't know if anybody was on it when I was there, but thank you. Okay, thank you very much, because it was almost not quorum, and everybody had to vote in my favor, but so thanks for that. But I am by trade, I am a librarian and an information scientist, but I generally like work in nonprofits. Haven't worked, I work part-time as a librarian sometimes, but I mostly work in like the nonprofit sector, and I'm originally from Chicago.
Seat 11, Bruce Wolf, our chair. Bruce?
Sorry, you'll see her from time to time. That's Yukon, my service dog. So my name is Bruce Wolf. I am a New York transplant. I've been here about 30 years. I became interested in San Francisco transparency, open government when I was a reentry student at City College in the mid-90s. And there was a big upheaval with the Board of Trustees there because they weren't being very transparent. And this was before the Sunshine Ordinance was voted in by the voters. It was just a simple ordinance at that time. And we really tried to get those Board of Supervisors to adopt it, and they wouldn't. In 2005, I decided to join this group and served on it till 2012. Which at that time, my colleagues and I were unceremoniously removed, which is a long story. There are plenty of headlines. You can read about it yourself. At that time, though, the task force, as you may know, requires a person with a physical disability to be appointed at all times. And when I was not reappointed, the task force could not meet, and that went on for about 6 months. And the complaints piled up and piled up. Chris Hyland was there at the time. He had gotten appointed during that time. I didn't get reappointed until 2016, and I've been here now. This is my second term through that. I have a great interest for this, a great love for it. I'm a chief information officer, but I'm a social worker. I have a bachelor's and master's degree in social work. I work for an organization called Alcohol Justice in San Rafael. We're an international organization now. We're a harm reduction and consumer advocacy group. We monitor predatory marketing on kids by big alcohol companies. That's the best way I can say it. And we do a lot of FOIAs and information request work. So this, fits right in. I, provide a lot of, help with regards to that for our own work as it is. And so I'm really happy everyone is here and your interest and raring to get to work on this. And so let's move on with our next introductions. Item C, our administrator and legal advisor. Administrator is Cheryl Leger, and our legal advisor is Mark DCA Deputy City Attorney Mark Price Wolf, and he's going to introduce a new member of his team. Cheryl?
Yeah, I am a Sunshine Task Force Administrator, and I've been doing this job since May 1st, 2018, I believe. And I've had the pleasure of being guided and advised by my colleague, Victor Young, who's taught me mountains of work, taught me how to do my job. He knows everything about it, and I seek his advice and counsel all the time. But I'm the go-to person, so if you have questions or you need a copy of something or you want to know where to locate something, I'm more than happy to give you assistance. You can either phone me or you can email me, and I'll do my best to get in touch with you within 24 hours. I have the one thing that I do provide for the task force during the full task force hearings is what's called an administrator's report. That will be reviewed towards the end of the meeting. But it's something I do, and it just gives statistics, a list of cases that have been opened, and whether we get public comment from people. Occasionally, people will submit emails and say, please include this as a public communication. So I put it in my administrator's report. And yeah, I have a bachelor's degree in literature and history. And yes, that's it about me. Victor, do you have anything to say?
Yeah, go ahead. Victor is our just former administrator, but is a great help and continues to help us here. Victor, why don't you introduce yourself?
Victor, are you on mute?
Yes, he is. Maybe he's not near his machine. We'll come back to Victor.
Okay.
Okay, Mark.
Hey, y'all. Mark Price Wolf with the City Attorney's Office. It's nice to see everyone and see some new faces. I've been with the City Attorney's Office for a little over 3 years. Sorry I wasn't on screen during the meeting. I sort of hide in the background, but I'm listening, and then I'll chime in when you guys ask for advice. And I'm always happy to provide advice, but I usually just wait until directly asked. So feel free to ask during a meeting, or if you have legal questions on the side, I'll respond via email, hoping that it's something that everyone can collectively benefit from. A little bit about myself. I too have succumbed and got myself a COVID puppy. Maybe I'll show you guys a little bit. I'm trying to keep him away. Never ever thought I would get a dog, but I was the last holdout, and my kids are thrilled. But anyway, before I was at the City Attorney's Office, let me just tell you the other hat that one hat that I wear is advising the Sunshine Task Force, but I wear a lot of other hats there, working on a lot of affirmative litigation with the City Attorney's Office. And just to briefly explain my role, is even though I am with the City Attorney's Office, I'm your attorney, like general counsel of the task force. So there's, I think Bruce will probably talk about this in orientation, or I'm happy to talk a little bit. There's a bit of what we call a due process wall, or just like a ethical wall, whatever you want to call it, a wall where any issues that you deal with, I'm your attorney giving you guys advice. So like today, all the discussions you were having about the city attorney's position on things, that's something I have no idea how they were responding to the complaints. I don't talk to them. I'm not allowed to talk to them about any of the complaints. I don't. All the agencies that they advise, I don't have anything to do with that. I'm your attorney here giving you advice on issues that come up. So something you guys should know, we take really seriously, and I'm here to help. A little bit more about myself. Before the city attorney's office, I was at the U.S. attorney's office just down the street doing criminal prosecution for several years. And before that, I was in a private law firm doing all sorts of complex litigation. And I want to take this opportunity to introduce my colleague, Helen Castillo, who I'm going to be sharing duties of advising the Sunshine Task Force. Helen has just rejoined the office, and I'll let her speak for herself. But we haven't quite figured out how to share the duties. Probably every other meeting we'll attend, but we'll be sort of in constant communication with each other so as no balls get dropped, and we'll both know everything that's going on. So I don't know if Helen was having trouble unmuting herself. She was that guest, Bruce, when you were wondering who that was. She was trying to talk. She texted me. So hopefully, if you can now, Helen, introduce yourself, or else I'll talk more about how great you are.
Sure. Can you hear me?
Yep.
Yes, we can hear you great.
Okay, great. Hi, this is Helen Castillo. Thank you for allowing me to join you. I did just rejoin. I had been with the city attorneys back in, in the early 1993 through 2000, and then I took a long hiatus. And most recently, I've been doing some work with the legal aid of Marin and with a private attorney in Marin County. But I have 2 children. I have experience working on the litigation team as well as the code team with Mark, the one that he's on now. So we do affirmative litigation, and in my former life, I've also been with an insurance defense law firm in San Francisco. But I have 2 children, and I look forward to working with all of you.
Okay, great. And I'll just ask again if Victor, if you're there, you want to introduce yourself? Okay, well, if he shows up, we'll stop and have him do that. Otherwise, you'll see him at and hear him in other meetings. Okay, moving on. Our next item is just to review other officials and entities that we interact with. As you may have read in the Sunshine Ordinance, there are two other seats that are non-voting. One is a representative from the mayor's office, and one is a representative from the Board of Supervisors clerk's office. In my tenure, we only had those seats filled once. It was when Gavin Newsom was mayor and appointed actually an attorney, fairly well-known attorney, who was a very interesting fellow, had interesting ideas, but was helpful in a lot of ways. The clerk has attended a couple of meetings here and there. She generally relies on Cheryl and Victor to provide any highlights or any additional information. She doesn't necessarily feel that she has much input on generally on cases or what have you. So we might see her, we might not see her, or a representative sit in that seat as time goes on. Other officials that we connect with are those that we may provide referrals for enforcement. The main one would be the Ethics Commission. We do connect with the investigations unit of the Ethics Commission because we sometimes need to decide whether a case to be referred should be sent directly to the Ethics Commission or whether it needs to go through the investigative unit and how that works. At the same time, back in 2012, when I had just left the task force at the time, we were right in the middle of negotiating special referral rules on how the task force is referrals are regarded when we make them to the Ethics Commission, and how they are able to adjudicate sunshine requests, complaints, I should say, sunshine complaints on their own directly. They have the authority to do that. More times over any, they won't. They try to refer as many of them as possible to us first. Let us have, do the work of overseeing the Sunshine Ordinance. But they will hear our referrals. There are two ways that goes. It's bifurcated. A 6734 willful failure generally goes directly to them because that is considered official misconduct, and the Ethics Commission manages all official misconduct hearings for the city. When a 6734 referral is made, that is the only time for us in Sunshine that it gets reviewed by their investigations unit. If we send a referral for enforcement for any other reason, like for instance, it could be sent for multiple violations and we want enforcement on a respondent for multiple violations that seem purposeful, it's rare. We have done it before. Then that goes directly to the Ethics Commission without any review by staff. So it's there's a choice, and we will probably have lots of discussion about that as time goes on. Other entities are the DA. We have the ability to refer items to the DA, and we've been in. I've had some very interesting discussions with them about them providing enforcement for us. Their concern is that there has to be a crime for them to take on a referral, any kind of prosecution. So but they're very open to seeing how they might be able to help us. the California Public Records Act and the Brown Act does mention them directly for various different purposes, and it's just not. It's unusual that they will take up a civil. According to that office, it's unusual to take up a civil case. They take up civil cases all the time for all kinds of reasons, and we just have to find a way forward working with them. The other one is the Attorney General's office. We don't interface with them that much. We don't get much response when we send referrals to them. They generally try to send it back down here locally. So that's the kind of thing. I don't know, anybody else, any other entities that you can think of that we might interface with? No? Okay, great. So let's move on to a little bit of review of our bylaws, the complaint procedure, talk a little bit about, just Robert's Rules of Order and the statement of incompatible activities. Those are attachments in the agenda. If you would open them up, we can follow along. I'm not going to ask. I'd love to be able to sit and during retreats and read through these things so we all know we're all on the same page. I'm not going to ask that we do that today, but I would really urge you to get familiar with these documents because it really is the kind of how the mechanics of how this this body operates. And lots of times in any organization or any business, the way they have their bylaws or their articles of incorporation or what have you, generally is not common sense. They do things very purposeful. So it's important trying not to kind of review and refer to these guiding documents first before applying common sense. If you think that something doesn't make sense in here based on your common sense, then that's good fodder for our rules committee to discuss. And maybe there'll be a recommendation for an amendment. And these are living documents, so they can always be changed from the time, at any time based upon what's happening around us. So basically, just note what's really important that everybody should know is about attendance, because that is something that is just pretty automatic. It kind of operates on its own. So it's not something that the task force really has any authority over. It really is incumbent upon you to maintain your attendance. And it gets pretty automatic when people start missing meetings. As you know, we have these holdovers. We don't have any holdovers right now. And just so you know, it does not follow the city's holdover policy, which is 60 days. We are considered somewhat of a odd bird because we were created by a vote by the voters. So the charter section that governs holdovers doesn't apply to us. And this is more kind of, there's some discrepancies and conflicts around how we're supposed to be regarded in the city that might be of some conversation in the future. The duties of the chair and the vice chair. The one thing I will say is that we need to have elections for the chair and the vice chair. It's supposed to be done every year. These appointments are pretty much a year late. Generally, we get appointed, it's supposed to be in April. Generally, it doesn't happen until probably May or June, but because of the pandemic, everything has been pushed back pretty far. So you're basically serving through the end or the rest of the existing term. For some reason, my seat 11, is the only one that's staggered, and I'm going to have to seek reappointment in April sometime, if not sooner. I have no idea why that one was staggered. it is actually designated specifically for a person with disability. And that's another whole discussion that actually I've been having with one supervisor. I would just read through the conducts of meetings. We generally follow the Ralph M. Brown Open Meetings Act, which governs all local agencies, and the code sections are in there. And we also we're not necessarily considered a policy body, but we impose in ourselves everything that applies to a policy body, because we should be setting the example for the rest of the city, and we do our best to try to do that. To some members of the public's chagrin, we do make mistakes, and sometimes because we're all volunteers, things get really slow, or things get missed. But for the most part, we try to do our best to follow the Sunshine Ordinance to as nth degree as possible. There's not much else that I think I can bring up through here. Our standing committees are the Rules Committee, which doesn't meet. It only meets when necessary or when items are referred to it. Then there's the regular committee meetings, which are the Education, Outreach, and Training Committee, which Chair Highland runs. The Complaint Committee, which Chair Schmidt runs, and Compliance and Amendments Committee, which Chair LaHood runs. We have one special or ad hoc committee, which is the IT Committee, because we're dealing with lots of new technology or technology that is finally making its way into Sunshine. We usually activate that committee to get a review from the departments that are or contractors that are providing them or implementing them. And it could be for anything else. We kind of started that when at metadata first started becoming an issue around searchable PDFs, because the city was making scans, like image scans of PDFs, so they were not searchable. They were just pictures. And so they weren't true copies. So that's when we started the IT committee during that. And it's been very helpful, as you heard earlier today, with regards to metadata in all kinds of files, including email, which is now pretty common, and because of new law that has come out too. I'll stop there for bylaws. Is there any questions or comments about bylaws?
Hey, should we talk about committee assignments now or maybe later this evening? I don't know if that was for the new folks.
Sure.
Segue into that or not?
Yeah, we can do that.
Vacancies on them.
Yeah, that might be a good idea if people have interest in joining a specific committee. Some of us are doing double duty because we hadn't had enough members. So yes, Member Forsley. And then
Hi, thank you. I just wanted to confirm, and I might have missed it in the reading, sorry. But for the different committees, did you say that all of the different committees can hear initial complaints? Yeah, that's the question.
Yes, so the way we work it is the primary committee that all complaints initially run through is the complaint committee. That's their charge. When we start getting a backlog, we then filter the backlog off into the other committees, and they are authorized to hear complaints for the purposes of complying with the 45-day rule in finding whether records are public or not, and we add on whether they apply to jurisdiction of the task force. And those 2 points are really important. Well, the 45-day rule is just a time factor, but finding whether they're public or not is really important, because if we don't find that the records are public, because they may be, let's say, protected by HIPAA, for personal medical records, and they are not necessarily, they're part of a private hospital that does not contract with the city, but somehow somebody thinks there's a connection there and thinks that they're governed by the Sunshine Ordinance. So taking that as an example, the committee can find that they are not public and then make a recommendation to the task force that they found that they are not public. And the task force can then, because there's more, maybe some new information came, or somebody else has other information, might say, oh, wait a minute, actually, maybe they are public. And so that's why we don't allow the committees to make final decisions, because it's just a committee of 3, and the public should have the privilege and the pleasure of hearing all 11 of us in the room as a brain trust in that way. Everybody comes with a different experience, so that's kind of the way it works. Member Frazier.
Yeah, I wasn't sure if we had to put on a sorting hat or anything like that for committees, but I saw that the Education and Outreach Committee only has 2 members according to the website right now. So if there's a need, that one caught my eye. Not sure how the process works.
I'm sure Chair Highland would welcome you with open arms, because I default for any vacancy as the chair. So, plus I think I have the most flexible schedule of anybody.
Bruce?
Okay, yeah.
Quickly, do you want to, I'd like to also, while we're talking about committees, mention that you've been serving on both complaints and compliance and amendments. And if anybody has an expressed interest in either of those committees, to relieve you of having to sit on 2 committees and the task force, to just extend that arm to anybody who might be interested.
Yeah. So you don't have to necessarily make a decision tonight, but you should let me know what committee that you're interested in, and then we'll see if who wants on what, and we'll kind of figure it out. Plus, there's also a scheduling issue, because generally, like I said earlier, our meetings when we're in City Hall, actually physically meeting in person, Tuesdays and Wednesdays, well, just the first Wednesday of the month is for the task force meeting, but Tuesdays we generally have the room reserved for our committee meetings. And so we want to make sure, depending upon which day of the month that committee meets, that it fits with your schedule too. That may be a factor for you. And we can try to see if there's another day available in that hearing room, if possible in the future. But for right now, we're remote. We generally keep these days and times because that's what's familiar for the public and the city family. So it's just kind of routine.
I just want to mention quickly that most of, as Bruce said, those meetings, the committee meetings are on the 3rd and 4th Tuesday of the month. The complaint committee meetings start at 5:30, and the compliance and amendments committee meetings start at 4:30 in the afternoon. So if that's, you might want to think about that in terms of your schedule.
And I'd like to add that I seem to be on nearly every committee because I bounce from one to another as we needed folks on each one, but I can't be on every committee. So if you see my name, by all means, don't consider you take my spot because I can't be on 4 committees at once. So I'll try to fill in where needed after everyone gets a spot.
Generally, the chair and the vice chair act as default. So if somebody can't make a meeting, just so we can maintain having 3 instead of 2 people on a committee, one of us will, kind of fill in ad hoc as need be, on call kind of thing. So think about it and let me know. Moving on, let's move to the complaint procedure. Again, I'm not going to go through it. This is a must read for everyone. It's why it's so important is because this is what governs how the both parties, the petitioner and the respondent, what their responsibilities are, what we ask of them to do, and how we are supposed to assure that the process is properly implemented and maintains fidelity. It also prevents, people trying to violate or cut the line, so to speak. And there's a concise way, it's kind of an agreement among everyone that this is the way that we're going to run these hearings. Now, we're always looking for ways to optimize it and streamline it and make it go, faster and cleaner or more, how should I say, more, just optimize it, I think is the best word. But any input on it is very welcome. I see Member Highland and then Member Forsley. Member Frazier, I'm sorry.
Yeah, I was just going to say, I think the next item 8, will help a lot of the new folks because it's a complaint form that we're working on, but that'll give you some insights too. So maybe even print off that draft and add that to your materials and above. I think you'll find that useful.
Sure. Member Frazier. Oh, okay, he thought he had his hand up. Never mind. Okay, great. Okay, so again, the complaint procedure, very important. Please make sure that you're very familiar with that. The next is the statement of incompatible activities. This is important. It's not something that we created. It is something that is imposed upon as you can see by its title, the Board of Supervisors itself, the Clerk of the Board, the Youth Commission, and the Sunshine Task Force. And these are really kind of the only kind of bodies in the legislative branch. There really are no other bodies in the legislative branch, meeting bodies. All the other bodies, boards, commissions, what have you, are all in the executive branch. And so if there are any concerns about this, I mean, this is something that has to be negotiated. Some are requirements based upon state law, based upon the charter, based upon various existing codes and civil service rules, because folks are employees, and frankly, every one of us is considered an employee of the city. Okay, even though we're volunteers, we are considered employees. If you want an explanation of how that works, the best person to talk to is either Victor or someone else at the clerk's office. I don't know Cheryl. I don't know if you know enough about how that works.
I'm sorry. Could you repeat the question? I was typing something.
Whether you know about our status as employees of the city.
Whether I know about status as employees? No, I don't know anything about that.
Right. So, and also you should know that you're all considered, or we all are considered public officials. So you are an actual public official. So that's why the statement of incompatible activities is important. You'll see if you scroll down to Roman numeral 2, the last paragraph, it describes briefly what we do. And then in item number Roman numeral 3, it goes on to then talk about the compatible activities. And the part that applies to us, well, there's obviously the area around being a registered lobbyist. But if you go to I think it's number 4, Like my go scroll. Let me just scroll. It's actually B1. And it's a short paragraph. Unless otherwise expressly permitted by state or local law or regulation, no officer or employee may assist or advise or represent other persons or entities concerning Sunshine Ordinance complaints or concerning matters that may appear before the Sunshine Task Force, regardless of whether the activity is compensated. Nothing in this section prohibits an officer or employee from providing factual information or, as part of the officer's or employee's duties, information about city laws, rules, and procedures, if that information is available to all members of the public. Now, why is this important? Because once people find out that you are a member of the Sunshine Ordinance Task Force, they're going to want to talk to you about their complaint or their issue or their problem. And anytime they talk to you about anything substantive, that could possibly turn into a complaint, you might be asked to recuse yourself because of ex parte communications. So the best thing to do if somebody asks you for advice or information or anything like that is to stop them cold in the tracks. I don't care how you do it. You just get them to stop talking and say, please make it hypothetical. And so if it seems like it's still too detailed, then tell them to make it even more general as possible. And that way you're talking in a hypothetical manner, and you would more or less apply what is factually available to them already. If you want, they want to get you to brainstorm about intricacies or how you might think about things and make decisions and stuff. That's not a very good idea. Okay, so that's an important factor. And this is generally for items that are within the jurisdiction of the task force itself also. So it's just a caution. If you have any concerns or questions about it, Mark is here to help advise you if you're concerned about it. If it's something important to you, or maybe to your neighbor or to your, a business that you're connected with, or somebody on your block, or anything that's happening like that. Maybe you serve on a board of directors somewhere else that maybe wants to file a Sunshine complaint. How does that work? That then leads to the other discussion is, what if you have a complaint with the city on a Sunshine request? How does that work? Well, that is something that we're going to need to discuss because we don't have a rule for that. And generally in the past, task force members have recused themselves and have become party. But at the same time, if you're recused, you're not supposed to be in the room because that essentially creates an undue influence, has an appearance of creating an influence. So we're going to have to figure out how that works. Some of the things that we've talked about over the years is actually allowing task force members to submit complaints to the task force internally. The task force would then decide whether to take it up, together, and it's still a topic of discussion, and we will continue to have that discussion as the days, weeks, months, years goes on. So think about those things. If you have any thoughts, get them out on the table, and we'll get into a committee so it can be fully discussed. The next and last session is the meat of the work that we do, is the Sunshine Ordinance itself, the California Public Records Act, and the Ralph M. Open Meetings Act. And I would love to sit here and go through the whole thing so we're all on the same page and have a big discourse about this, that, and the other thing. I think it's a great exercise that, we should maybe have a big public forum on and have the public and the city folks come and everybody sit around a table and have, discourse around it. But for now, avail yourself to read the ordinance. I miss things all the time in all the years that I haven't, for some reason, haven't like clicked in my head. Members of the public have been great to pick up things also that maybe of interpretation that we've been overlooking or maybe hadn't thought about before. And also the city family has brought things to our attention that that also apply to. That's been very good. And so just so you know, the Sunshine, again, I mentioned this during one of the cases today, the Sunshine Ordinance is an enhancement of the California Public Records Act and the Ralph M. Brown Act. It allows for, this is one of the few laws that actually allows for more transparency, you know, than what is already offered by the state, that it can be implemented at the local level. To date, we have some, I think we're still one of the strongest sunshine ordinances in the country. But others have followed our coattails on it. And there are still other areas, municipalities that are looking to implement them, and they implement them differently. The one thing that we don't do well is that we have oversight on complaints and compliance of all three laws. Most of the time, we are finding, if we find violations or if we're looking for implementation or compliance, it's only with the Sunshine Ordinance. Okay, we assume that if we're looking at the Sunshine Ordinance, that's the penultimate. But we are also not looking all the time at the CPRA and the Brown Act, and including those sections that of noncompliance in our orders of determination. And that is something, the reason why that is because we don't have a good correlation as to which section of the ordinance applies to which section of the California Public Records Act, the Brown Act, and that is one of the projects that we're going to be talking about in a little bit. Any questions on the ordinance, CPRA, or the Brown Act? Or any comments? Okay. Okay, with that, I'm going to open it up for public comment on item number 7A through F.
Are you calling, folks?
Yes, public comment, items A through F.
Mr. Warfield, are you ready?
I have to get my timer ready. I guess I'm ready.
Go ahead.
This is Peter Warfield, Executive Director of Library Users Association. Thank you very much for having this section, and you certainly could have much lengthier discussions about almost any aspect. As somebody who cares about books and libraries, we have been in existence for a long time as a Library Users Association, and also prior to that I brought complaints on my own, and as I said, won most of them, though not certainly all of them, and I've seen a lot of the history of the Sunshine Task Force. There used to be a thing called the Sunshine Posse. Many of us are still around and might be considered a posse, but Sunshine is really crucial for anybody who's a journalist or a whistleblower or anybody who is concerned or interested in what's going on. And unfortunately, in the city, there has often been rather flagrant violations because there is, well, let's just leave it at that. I do want to say that the beginning of the Sunshine Ordinance is a beautiful phrasing, as is the two state laws. The Board of Supervisors and the people of the City and County of San Francisco find and declare A, Government's duty is to serve the public, reaching its decisions in full view of the public. B, elected officials, commissions, boards, councils, and other agencies of the city and county exist to conduct the people's business. The people do not cede to these entities the right to decide what the people should know about the operations of local government. And I think that's quite nicely stated. There's a whole range of issues that I think you will need to be facing. First of all, your chair, Bruce Wolf, did not mention, although he mentioned quite a lot, the role of advising the supervisors with respect to how well Sunshine is working and possible improvements. Sunshine Task Force is known to be weak, unfortunately, with respect to enforcement. We pushed hard to get the full task force not to meet on Tuesday because that conflicts with the Board of Supervisors. Unfortunately, your committees now seem to be meeting on Tuesdays, and it would be great not to. There's a whole lot of history, and let's just say that when I started going to Sunshine Task Force, they had just installed a chair who had been president of the Library Commission and who was known to be very hostile to Sunshine.
Your time is up, sir.
I get 2:58. I keep coming up short here. But there's a great deal to be discussed, and I hope you will take up a great deal of that, in particular the history. Thanks very much.
Next speaker. Okay. Any other public comment? Last call for public comment. Okay, seeing none, let's move on. Try to get through some of this pretty quickly. So, yeah.
Just two quick things. Number one, we should probably announce that Member Frazier is left.
Yes.
And then
go ahead.
just for so the task force knows, we do have members who are short. Just to maybe touch on how the 6 vote requirement. I don't know if you wanted to do that, Chair Wolf, just so that doesn't come as a surprise to anyone.
Right. So, and one thing I didn't get to was Robert's Rules of Order. We generally run Robert's Rules of Order. We don't really use them to the nth degree. It's just to kind of generally keep things in basic order, and just so there's some understanding of how to make amendments when you want to replacement language, things like that. To be honest with you, we generally don't do friendly amendments. There really is no such thing. That's something that is kind of casual in a lot of organizations, but for a government body, there really isn't. It shouldn't be done. And so I'm not going to encourage friendly amendments unless it's something very simple. That's not substantive. If it's a substantive change or addition to something that's currently on the floor, simply just make an amendment to amend. Make a motion to amend a motion that's on the floor. We take a vote on the amendment. There'd be public comment and all that, and then it'll be part of the original motion. Just to keep things in order. It's something that the public expects, and it also keeps things clean on paper of the actions that were taken. Sometimes it's best for us to be a little clunky and a little blocky and taking things step by step so that we're sure to cover every track that we're doing. You've been experiencing how we basically run the meetings now from the beginning, and it basically runs this way. If you feel that there should be some changes or anything, happy to to hear your thoughts on that. If it help make the meetings run better, smoother, what have you. Okay. Yes. Somebody speaking? No? Okay.
Just 6 votes.
Oh yeah, 6 votes. So, so there's a requirement. We have a requirement that for substantive issues, actually for mostly everything that we do, that there has to be an affirmative 6 votes in order for anything to pass. This is somewhat equal to the Board of Supervisors and the way they operate, and there is no abstentions. There are no abstentions. That is up for some discussion because there are passages in the Brown Act that speak about the recording of abstentions. And then the question is are we one of those bodies that are in the charter section that would have to actually abide by that? I'm not going to get into that because some of that is also what got some of us in trouble years back. So I'm not going to dive into that too much. But if there's discussion among us as a group that something like that comes up, let's definitely have that discussion when the time comes. So that's why your presence here and your decision to make this commitment is so important, because we have been operating on 7 members, and when if somebody is not there, and there's 6 votes or 6 people in attendance, there could be what's called tyranny of the minority. All it takes is one person to vote no on everything, and nothing gets passed when it possibly should on its merits. The other thing is that we've had to cancel meetings because of lack of quorum. So it's really important that we maintain the full body, and we have to when it drops down or we have vacancies. It's important for us to get on the appointing by the Rules Committee of the Board of Supervisors to hurry up and get us filled. Okay, any questions on that? Okay,
May
great.
I say one thing?
Yes, sure.
It's Peter Warfield again. Essentially, your absence is a no vote on any complaint that comes in, and it makes it much harder for folks to get what ultimately ends up as a kind of supermajority, as Bruce says, when there are 7 and 1 is absent. But even when there are 8 or even more, even one absence, let alone 2 or 3, and a vacancy, and all of a sudden you have to get an almost insuperable majority as a complainant. So basically any member's absence or a vacant seat under the current rules, and that perhaps ought to change. It's another story, and it has in the past, but it means a no. Essentially, the effect is a no vote on any complaint.
Okay, thank you. Okay, so getting into our special projects, again, I mentioned before a comparative analysis of the CPRA and the Brown Act to the Sunshine Ordinance. This is kind of open for anyone who is interested in doing this work. I'm just kind of leaving in these items to be somewhat of an open door, because the work does need to be done. We don't have any budget yet, but we've never had any budget. So we don't have additional staff or the ability to hire a contractor or anything like that to do this kind of work. So if this is of some interest to you, let me know, and we could possibly maybe steal away a little bit of time from Helen and Mark to kind of review anything that might come up that be of some question, to see about doing that. But we should really try to see when we are making our orders determination, we should really try to connect both the Sunshine Ordinance with the other respective body of work. Any questions on that discussion? Any public comment on that?
Yes, please.
Cheryl?
Hang on. Go ahead, Mr. Warfield.
Hi again, it's Peter Warfield. One of the things that Supervisor Peskin said at the Rules Committee meeting, I believe, was that there were he mentioned two problems that the Sunshine Task Force has. One of them he mentioned was staffing. And I think that's very important. And I have to disagree with the chair with respect to having no budget. Section 67.30, the Sunshine Ordinance Task Force, has a clause, number C. It starts out, the task force shall advise the Board of Supervisors and provide information to other city departments on appropriate ways in which to implement this chapter. But then it goes on to say, and that's what I referred to a little earlier, your advice role. But it then goes near the end of section C, the task, well, maybe I'm not reading the right one. Responsibilities for administration, I think that's the one that counts, for 67.31. The clerk of the Board of Supervisors shall provide a full-time staff person to perform administrative duties for the Sunshine Ordinance Task Force and to assist any person in gaining access to public meetings or public information. The clerk of the Board of Supervisors shall provide that staff person with whatever facilities and equipment are necessary to perform said duties. So I think that's pretty clear that in that regard, there is a requirement to provide what's necessary, and I would view facilities and equipment in the broadest possible sense. I also would be concerned about the legal advice that you have. You're required to have an attorney, and I'm not sure what section, perhaps Bruce knows which one that is in particular, but I think that you have a requirement as well for legal advice, which I think you should fully exploit, if you like, fully use. And one of the things I think would be important and an improvement would be that whenever you do get legal advice, especially in public meetings, that should be documented so that it's available as part of the history of the task force and how you thread your way through complaints and through
30
other
seconds.
aspects. The lack of a good history, I think, is a serious drawback to the task force and its ability to help the public. The history of decisions, history of rulings, and so on, and interpretations. Thanks very much.
Any other public comment? Last call for public comment. Okay, seeing none. Okay, public comment closed on this item. I would just add that our legal counsel is provided us pro bono by the city attorney's office, essentially the city, and the clerk, our administrators paid out of the budget of the clerk. But the task force itself, unlike all other boards and bodies that are similar to us, we don't have a budget. We don't have a line item in the city budget. And that's kind of what I'm referring to. Yes, we can ask for things from the clerk's office, but everything gets very tight, and it's not easy. So we are going to ask for some items, which leads us into the next section of technology, the orders and determination searchable database. This is really important because this is our history of all the decisions. This is our case law. We don't have the ability to easily search for that case law to see what decisions we've made in the past based upon decisions that we all are going to make from now going into the future. And it's really important to refer back to those, because if we've already made, dozens and dozens of decisions based upon current complaints that are just, replicants of previous decisions, there doesn't need to be a whole lot of more discussion about them, because a lot of the meat of how those decisions got made are in these existing orders of determination. So it should be fairly kind of pro forma in a lot of ways for a lot of complaints. We just don't have a way to be able to, when a complaint comes up, and doing any kind of review or creating a summary or actually a legal memo of some sort to refer back to those our own case law, so to speak. So it's been a real sore spot for us. Yeah, Member Stein.
Do the orders of determination give a rationale for why a vote went a certain way?
Yes, it provides excerpts, kind of a summary from the very beginning of the complaint process. So from the complaint, the jurisdictional side, then to the task force hearing, and then there could be multiple motions that are made, and it gives some kind of just some it paraphrases what happened in that period of time, but you can then refer back to the minutes, the actual minutes, if you need more detail, or the actual audio playback if you want to hear what was actually said. So there's a lot of ways to research that, but it really has been hard because people will come and they'll say, they'll actually tell us which orders of determination we've already have done and ruled on, and say the one that complaint I'm bringing forward is just like those, so you should find in my favor. And it sometimes throws people for a loop because haven't seen it before, don't remember it, that kind of thing. So we are not here just for who we are here. We are now, carrying a continuum starting in 1999, and so some of those interpretations of those order determinations may not be correct anymore, or maybe it's a different interpretation. I'll just leave it at that. It's maybe they're not correct, and maybe they need to be revised, or maybe they need to be flushed out some more. Nonetheless, we've been working on trying to build a searchable database online that's available for everyone to use. And so I've been working on that because, being a tech professional. But if somebody else has some interest in that, wants to work with me on it, great. I thank you, Jen. Yeah, great. Kai, that's great because that's something desperately we need. The next one is this automated metadata system that we heard a member of the public, Anonymous, had mentioned. That is something we don't need to actually do too much more work on it, but it has to be reviewed and monitored, and we should probably get an update and a kind of a presentation by the Department of Technology on it, and that will go to the IT committee. And so if you're interested in joining the IT committee, it meets ad hoc, it's not regular, but whenever we can get a meeting together and get those folks to show up, then we'll have that. If we need to do it sooner than later because it's something important, then let's make sure that happens. The next request system. Next request is a new platform that is now being implemented throughout the city. A lot of governments are now using it. It's a way to make public records requests online. It allows you to have actually open a ticket, and then you can follow anybody that touches that ticket. It records it, so you can see even if somebody opens it just to read it. That's in city government. You'll see who it is and when they did it. It'll be a date and time stamp. It's got its good points. It's got its bad points. Depending upon who's using it. There's a lot of questions around the public's ability if it's accessible. What if people don't have access to the internet? Things like that. Everything always falls back on hard copy and snail mail. Government cannot rule those forms of access out. Okay? They can't force people to use the internet. So that is, because we still have a huge digital divide or lack of digital inclusion here in the city. People, and now with the pandemic, the library is closed. So people who use the library for internet access have no access. So you'll start hearing complaints, and you may hear respondents say, well, people didn't send it to the right place, or they're not supposed to send it there, or this, that, the other thing. You'll read in Sunshine Ordinance that's different than the California Public Records Act. This needs to be said. California Public Records Act applies to agencies, departments. It does not apply to individuals. The Sunshine Ordinance enhances that by applying to increase efficiency and maximum transparency and expediency. It requires that every person who possesses or is in custody of a record is a custodian of record and must answer to a request. And if they don't have the request, they must help the person find another person that might have that information for them. So that is how we assure that the California Public Records Act is being implemented as exquisitely as possible. That was what the framers of the ordinance and the voters were trying to do. So the next request system, while it's good, if not able to get to an internet, you can still send it by snail mail, make a phone call. You can do it verbally. Members of the public can make a request verbally, and in that kind of way too. So any questions, discussion on that? I'll take public comment after I'm done with the next one. The last item is pandemic related. Why is that important? The executive orders that the governor and the mayor has put in place that changed how the CPRA and the Brown Act and the Sunshine Ordinances be implemented is still today misunderstood. The city attorney has produced some rationale on that, interpretations, and some of that is very confusing to the public, and some, frankly, confusing even to me. And just trying to figure out what is applicable, what's not applicable, I think needs to be reviewed by the Sunshine Ordinance Task Force, and that we come up with our own interpretation of how we see those executive orders and how they're supposed to be implemented. The other issue is how much of it is really not in compliance. It really can't be done. It's not like this is not what it's meant. There should be much more transparency during this time than less transparency, because government isn't operating in its usual way, where normally there'd be a more higher level of transparency under regular time. So, Member LaHood.
Yes, I just wanted to clarify because I thought you were still referring to the bullet pointed technology items, and there's one that says pandemic related, but then there's also number 4 that sort of refers to the same thing. Are you viewing these as, because I'm interested in this area, are you viewing these as 2 different things or essentially part of the same piece?
Oh, I'm sorry. I guess I jumped ahead. I guess for technology under pandemic related, it's, you're right. Sorry. Thanks for reminding me. This is really more about what's happening here today. We all get
all in or use Microsoft Teams and things like that.
Right. Exactly. It's so let me back up. Save what I said for number 4. This part is about the technology that different parts of the city are using for actually holding public meetings. So the Board of Supervisors uses MS Teams, Microsoft Teams. Okay. The Public Utilities Commission uses Blue Jeans. Okay. The Planning Commission, I think, uses Zoom. Everybody's using something different, and there's nothing uniform. There is nothing that I like about Microsoft Teams. It does not work well on almost every platform that I use. I can get along with it on Windows, but I'm not a Windows user. I'm not a big Windows user. I'm actually a Linux user, and it doesn't work very well in Linux. So But at the same time, that means the public has to understand how all these platforms also work. And there's a lot of people, again, due to the digital divide, who are not tech savvy. And what happens if they don't have the internet? Okay, but they have cable TV and they want to be able to watch the meetings. They can go to SF.gov TV, channel 26. We don't get to be on that. And so the way that we get to see each other as members, the public doesn't. All they could do is hear us on the phone. But if we were in City Hall at a regular meeting in person, they would get to see all of us. So they should have the pleasure of being able to see us in some way, shape, or form. Maybe it should be streamed on somehow over the internet, so they could see it. Maybe it's on YouTube or Facebook, or private service of some sort that the city approves of. So that's what we're referring to. What I mean by pandemic related regarding technology. And I think we need to review to make sure that the Brown Act is being implemented properly in the use of any of the technology. The other thing beyond that is how they actually implement it. So I visit a lot of commission meetings just to see how they're running them. And I went to a planning commission meeting, and the clerk, the secretary, they don't have a clerk, they have a secretary of the commission. That secretary told all the commissioners at the beginning of the meeting to turn off their video. So now you're seeing an avatar with from that person. You don't know what they're doing. They could be downstairs doing their wash. They maybe could have stepped out to go pick up their kid from daycare, or maybe they're sleeping. But you don't know if they're actually there. How do you know that there's actual quorum? Okay, and so I contacted the secretary and I said, you can't do that. And his response was, well, yeah, but their internet connections are so bad that in order for them to have a good connection, they have to turn off their video. I said, well, that's not the public's problem. That's your problem. You need to fix that. The public has a right to know that their public officials are paying attention and in attendance to the meeting. Okay, I'll stop there. Questions, comments? So that's another project. We need folks to focus on that part too, and so that we can make recommendations to the Board of Supervisors. Board of Supervisors holds the purse strings. They can encourage folks to, fall in compliance, to come into compliance with the ordinance, by holding their purse strings. And this is a budget year. So this is the time that we need to do this kind of work, if we think it's important. Sorry, I'm talking a lot. I hope I'm not mansplaining. Okay, let me take some public comment and then we move on to try to get this closed up quickly. I know it's getting late. Public comment on this item.
Yes, Denta Tedessa.
Yes. Sullivan?
I'm sorry?
This is
Hello?
Denta Tedessa for public comment.
Okay.
Denta.
I hear you, sir.
Thank you.
Mr.
Let me know when to
go
begin,
ahead.
and please give me a 30-second warning.
Yeah. No, go ahead.
Okay, thank you. Sunshine Task Force members, my name is Denta Tedessa. Again, this is for those of you who are new. I've had some cases I had a batch of cases in the beginning of 2017 and then also in the beginning of 2018 regarding access to meetings, some more access to records, and my experience with the Sunshine Task Force has been mixed to very disappointing in the end. and in the end meaning now. The reason I say that is that the rules are not equally enforced for everybody. Seems like there are preferences, and I hope that the new members would take into consideration, take to heart that people with so-called no means and so-called no access to things, computers and all that stuff, that can be true, but the very basics are not being met in my experience. And in my experience, my quest for accountability and for just knowledge of what's going on in my personal case was met with defiance. It was met with rejection. It was met with outright blocking me to a meeting. On January 2nd, 2018, I was at a Sunshine Task Force meeting. In the middle of the meeting, my service animal, Rosie, was outside City Hall. The complainant that I had brought there against was the Sheriff's Department. They actually called ACC to pick up my service animal, and in the middle of the meeting, thank you. In the middle of the meeting, when I rushed down, they took my animal, and for that I said, this is unacceptable. I ran down to ACC, and the rest is history. But now, going back to the complaint itself, there's no record of video. There's no record of the audio is missing, and there's no mention of anything in the minutes.
Your time is up, sir. Okay,
it just needs to be fair. When somebody comes to you with this, I mean, I think this is a big deal. You ought to answer my questions. You ought to investigate why. That's all. Thank you.
Next commenter. Hello?
Sullivan? Yeah.
Hello, Mr. Warfield?
Yeah.
Okay, I'm ready. Are you ready? Go ahead, sir.
I'm ready when you tell me you're ready.
Go ahead.
Okay, good evening. It's again Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and by mail at P.O. Box 170544, San Francisco, California, 94117-0544. First of all, I'm very glad to hear a member of the public who's had some experiences. I think you need to hear a lot more in respect to generally how the task force is doing, and in particular on some of these issues. I have been begging the task force to do partly what your chair has just described you're working on, and in particular to deal with complaints or even just to talk about what's going on during the pandemic. It's criminal. It's atrocious. I have said earlier in this meeting, people are having trouble even getting into a virtual meeting. People are having trouble if they don't start the meeting, quote unquote, on time. I've heard of other people, and I myself have had trouble getting all of the comments that I wanted to because of one reason and another. The rules are incomplete or non-existent. They do not describe accurately what happens. The user is completely surprised constantly. And of course, all the different systems that Bruce Wolf mentioned have different things for everything. Raise your hand, lower your hand, indicate that you're interested, and so on and so forth. It's *3, it's *6, it's something else. It's maddening. Let me say this. The so-called digital divide has been vastly increased, and I would call it a digital abandonment, much more vicious and much more devastating to people who don't have computer access at all, of which there are millions in our country and over 100,000 in our city. look up City and County of San Francisco Digital Equity Strategic Plan 2019 to 24. 100,000 and more are without digital access. And who is the worst affected? Seniors, minorities, poor people. This is a vicious and simply
30
abandoned.
seconds.
We used to be able to go into an office 40 hours a week. We used to be able to make phone calls 40 hours a week. Nobody would say they're busy with laundry or anything else. And if it wasn't 40 hours during work hours, we could leave a message. All that is gone. And we're supposed to believe that these virtual meetings are any kind of a substitute. And
Your
there's
time is
no
up, sir.
call forwarding and such things as that to make up for it. This needs to be looked at desperately and seriously. It's disastrous for democracy and for participation. Thank you.
Do we have another public commenter?
Sullivan?
Mr. Sullivan?
Sullivan? Yo, great. I had a comment for the comparative analysis, but you guys can read it on your own. It's, I already submitted it. I wasn't able, I had mute problems. Are we on mayor's executive orders now? Can I?
We were
No.
just completing
No,
items
not
of
yet.
technology.
Okay, I'll wait then.
Okay, great. Okay, any other public comment? Okay, seeing none, close public comment, move to the next item. Next item is multiple complaint file consolidation. This is a big sore point. We have a big backlog. Part of it is due to a lot of complaints from one or more complainants, and also because of just the pandemic, and we lost almost 6 months of time to hear complaints. So we are trying to figure out different ways to be able to deal with that. Vice Chair Yankee and I have met with one of those complainants. That's been pretty prolific. That person was here earlier today as a member of the public that was anonymous, and because of the kind of work that he's been doing, which has basically been kind of a broad, like dragnet across the entire city government on how the ordinance is being implemented. Like he'll file, like 10 requests across 10 different departments and see what the response is, and then do an evaluation. But for everyone who's not compliant, they'll bring a complaint forward to us to have adjudicated, and so that way they can put the pressure on that custodian to produce. And they've been pretty successful, on various things, and not so successful on other things. But because we are volunteers, don't meet that often. We have one staffer and really no technology to be able to help us. We have to find a way to be able to deal with these kinds of complaints that come through. I've been strongly suggested by some city staff that we should, create a policy on what would be considered frivolous complaints. People who just try to make complaints to make life tough for city officials. I had heard another one where they say that we shouldn't allow any anonymous complaints because that could be abused. You could have, you don't know who's making them because there's no real control for it, like a control flag for it. You don't know if it's the same person or multiple people, or there's no idea how to track it. So this is we've started the process. If anybody's interested in joining in that process of the task force to try and develop a way forward on that, we've been having some very interesting ideas about that. We're going to form a committee next so that we can get all these out and so the public can, can hear it and participate in that too. Any questions or discussion on that item? Okay, public comment on number 3 around multiple complaint file consolidation.
Yes.
Mr. Warfield?
Am I the only one?
No, it was Mr. Tedeschi also wants to make a public comment. Are you ready, Mr. Warfield?
I didn't understand. It's really fuzzy. What do you say?
I said there appear to be 2 public commenters, excuse me,
Okay.
you and someone else. So would you like to go first?
Sure.
There you go.
Thank you. Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com or at P.O. Box 170544, San Francisco, California, 94117-0544. This is severely problematic. I'm glad you are thinking about what to do about a lot of complaints. But it seems, shockingly, that there's no sense, I'm not hearing a sense, that maybe there's a lot of complaints because there's a lot of violations. Every time the complaint procedure and the backlog and so on are discussed, very much there seems to be a bias. Let's slow down or stop complaints. Let's disqualify complaints. Let's toss out complaints. Let's find fault with complaints. Oh, it didn't have enough information. They didn't this, they didn't that. This is wrong and that is wrong. What about the persistent, repetitive, chronic violators? What about the widespread nature of the violations? The Anonymous has provided many complaints, including quite a few. Not only it looks like he's won a tremendous number, many of them were contrary to what the city attorney himself ruled. What are you going to do about outrageously chronic, consistent violators? You know, Member Highland said a very nice thing. Cheeky, he called the city attorney's action in one case. Others might call it not kosher. Others might call it chutzpah. All of that is something that you need to aim your guns, at least consider seriously what you're going to do with the endlessly repeat violators and violations. And not just keep going one by one by one by one or multiplying them. I can also tell you that combining complaints is very destructive unless it's done with care and well in advance. Very destructive. We've seen complaints combined at the last minute where it completely discombobulated a person who had carefully gathered information, who had carefully prepared their case, and all of a sudden you throw them into confusion. Even today, this
30
happened,
seconds.
where one of your complainants didn't know exactly what he had to deal with or even what the procedure would be. This is grossly unfair to the complainants. And you need to stop looking at what's wrong with complainants, although there's nothing wrong if you need to do that, but certainly need to see what has to be done with regard to violators. And I have to say that Next Request is a catastrophe, a disaster, a barrier to public access of the worst kind, and I could gladly talk to you about that if you'd like to
Your time is up,
ask
sir.
me about it. Thank you very much.
Hello?
Are you
Hello?
ready, Mr. Tedeschi? Just hang on a second.
Yes, sure.
Are you ready?
Yes, I am.
Go ahead.
Hi, yes, Sunshine Task Force members. Again, I don't think members of the public are want to file complaints just for the fun of it or for the, or for the to make people's life, public officials' life difficult. I take umbrage in things going that way, saying that blaming it on me. For God's sake, I was housed while I was filing complaints at the Sunshine Task Force. At the direction of the Sunshine Task Force, and me keeping that in mind, and me wanting for more evidence to actually show this Sunshine Task Force what is going on with my service animal and myself. I asked for videotape at my housing, complex, videotape of an incident, which the reason that her being off leash shows exactly my reasoning behind that and the logic behind that. And I was denied. Not only was I denied, I was evicted because of that. Now, I was evicted because of this same policy that barred me from going into City Hall. All of a sudden, a posting comes up in my housing saying that all service animals must be on a leash. Absolutely must be on the leash. There's no ifs, ands, or buts. This is while I'm having the complaints at the Sunshine Task Force regarding the same issue, regarding access to meetings, access to public meetings. To now go and say that that because of public complaint, I don't want to make a complaint, but I had to do it because I did not know what else to do. And to then turn and say that you're going to come up with things that limit my ability to file complaints, no matter how totally wrong it was in my case, but is wrong. You should always look at the public as the people who you're serving, if you
30
will.
seconds.
And know that people, especially in the lower economic class, that actually come to you with these complaints, they're not faking it. I'm sorry. They are frustrated because of what has happened to them, and they are there for help. They're there for relief. And lo and behold, later on, you find out all these corruption things in City Hall, corruption here at MTA, corruption. So it's almost like a harbinger.
Your time is up, sir.
What things are to come. So all I'm asking is, please keep that in mind. Please keep in mind that the public, especially those who are struggling, and they're not coming to you just because for the fun of it. Thank you.
Any other public comment?
Sullivan?
I heard you, sir.
Sullivan?
I heard you, sir. Just a moment.
Okay, no worries. I never know whether I'm on mute or not.
Are you ready?
Okay. Yeah.
Okay.
One of the things the task force could do is just track violations of the Sunshine Ordinance, as you guys find, as far as the city is compared to people who bring up issues. And you can either start this year or go back a little bit. It'll give you sort of an idea of how frivolous complaints are. And the only other thing is I had problems with my comments. I hope that maybe the task force will read my comments on comparative analysis of Public Records Act and Ralph A. Brown to the Sunshine Ordinance, which I already submitted. All right, thank you.
Any other public comment? Hearing none, public comment is closed. So members, we're just going to quickly go through the number 4, and then I think we're going to need to wrap it up. This is, we're getting kind of late here. And we'll take up some of the other items at the next meeting. The last item in for our orientation as one of the projects is, as I mentioned before, the analysis of the governor and the mayor's executive orders regarding the pandemic. It's not just this pandemic, it's any pandemic, any disaster, any catastrophe. How should things be operating with regards to the public's right to know? Because things do change under these extraordinary conditions. And there are some rules with regards to how things are supposed to operate, but they really are given, and I'll tell you, when you look at how things went back in March, and you look at the process wasn't very clean. Because we've never had to do this before since probably the fire in 1906. So it wasn't really clear on how to do this. So I think it's just really it's more of an analysis of this, and for us to create recommendations that actually should be added to the ordinance, specifying what's supposed to happen during a disaster, a catastrophe, or an emergency at that time. And so I noted it as being a case study. So I'll stop there. Any questions or comments? Okay, any of these are open for any of you want to, join in and either take up the torch or join with others that are already working on it. Member LaHood?
So I'm interested in working on this. I do not want to do it single-handedly, but I would love to be part of a group working on this.
Okay, great. You don't have to say it now. Think about it and let me know, or let Member LaHood. Actually, your communication with the rest of the members is through Cheryl. So the email address you have for the Sunshine Task Force, if you want to send a message to me or to anyone else, we keep a paper trail. So we use our administrator as the go-between. I know it's a little clunky that way, but it makes things easier. And if the public wants to see what we're talking about with each other, there's no smoke and mirrors here, no backroom deals kind of thing. So, all right. Any other questions or comments on this? And then I'll open it for public comment, and then we'll move this to a close. Public comment on item 4 in the analysis.
Yes.
Sullivan.
Mr. Warfield, are you ready?
Mr. Sullivan.
Mr. Warfield said he wanted to comment too. Am I correct, Mr. Warfield?
Yes, I'm fine if the chair wants to take Mr. Sullivan first.
Hey, please take Mr. Sullivan first.
Okay. Go ahead, Mr. Sullivan.
Given I have only 3 minutes, my comments are truncated, but they have already been submitted into the record. The Brown Act and the Public Record Act are state bare minimum requirements and cannot be suspended by the mayor. I would be happier with the mayor's executive order if one also froze the destruction of records under the city's retention policy. The fact that it does not and yet delays public access goes against the public access laws. I help the requester to secede the Sunshine 67.1D. Governments are doing is fundamental to democracy, with a very few exceptions. That right supersedes any other policy interest government officials may use to prevent public access to information. Destruction is prevention. Prevention. Mayor's Executive Order number 5-6A, suspension of notice of special meetings, is probably illegal under the Sunshine Ordinance and Brown Act because they already have allowances for emergency. Section 67.6D, if because of fire, flood, earthquake, or other emergency, follow these procedures for notice of special meeting. The same with the Brown Act 54954E. Brown Act 54956. 1 hour prior to emergency meeting or in the case of dire emergency. Brown Act 54956.5 already defines emergency situation. 1, that severely impairs the public health. So Brown Act emergency procedures should be followed. If Executive Order 7E were followed, it would mean a requester could directly plead to the court, which would lead to a greater imposition on the city. Thank you for your time.
Mr. Warfield, are you ready?
Yes, I am. Thank you.
Okay.
Tell me when.
Go ahead, sir.
Okay, it's Peter Warfield, Executive Director of Library Users Association, and I would like to very much know what Mr. Sullivan has provided and where to find it. I suppose I would like to ask the task force and maybe the chair and the administrator for whatever he might have sent you in connection with today's agenda items, and in particular this last one. I have been asking for there to be some work done for the ordinary public to understand what is going on with respect to the governor's and mayor's executive orders. I've been asking for this repeatedly over multiple months. And I think we're, 10 months into, 11 months into the pandemic. What does the task force have? I certainly agree with a lot of what the chair has said on this and a couple of the other previous items, and I appreciate it. But why does this have to be done behind closed doors? Why can't there be the public involved? Why do you only deal with a particular person who's giving you a lot of problems? What about the people who aren't giving you multiple requests yet because maybe they've given up, maybe they are hopeless about where the task force is, maybe they'd like to better understand where things stand for them. Open government is croaking, it's gasping, it's suffocating. Everything indoors, offices closed, telephones not answered. It's a disaster, and especially not just for people without access to computers or good access to computers, or who are the poorest, or who are the racial minorities, or who are the oldest. Those people in that report I mentioned, you'll find, have dramatically greater lack of access or good access. Then there are people who are disabled. There are people who have language difficulties, who have troubles following brilliant next request. You know, when I send somebody a request, I figure I'm looking for the answer to come from them, not from something that comes from a .com extension that looks like spam and doesn't tell me anything about which of multiple requests this might be. And it doesn't sort it into my file. I have a .gov file and an sfpl.org file.
30 seconds, sir.
Sorry, it doesn't work. Desperately needed, and you should include the public, invite the public, whether you do it in a public hearing or in a private meeting. Broaden it out. The public will tell you a lot and help you a lot. And you certainly have a lot of intelligent and very experienced and very knowledgeable users of Sunshine who have been currently or in the past known to you who could certainly help you.
Your time is up, sir.
Okay, any other public comment?
Yes, that's Tadessa. Yes, hi. Again, this is Dennis Tadessa regarding the question number 4. The analysis I would say would be that it seems like government takes advantage, if you will, of these types of emergencies for less government. What I found out through this past year was now that the memos that the legal that the city attorney gives to you, that is specially assigned to you, is no longer going to be listed on the complaints. And that process even would be perhaps even held under closed sessions, meaning the public does not have a right to hear what advice they are giving you. Attorney work product, attorney-client privilege, all these things are shutting down access to information, access to records, and access to meetings for the general public. I don't mean to be just negative with all the comments I've made this evening, but on the lighter side of things, Chair Wolf and then Vice Chair Highland were really helpful in terms of my complaints, and I could hear in their voice when they talked about it how how frustrating it was for them to adjudicate this particular issue with me. I really appreciated Mr. Young, the administrator, going out. He waited outside with my service animal because I was in a meeting for the whole meeting outside, and I really appreciated that. I really thanked him for that. Mr. Leger has just been going well over and beyond what she was required to do to help me. I understood that. It was a human contact. It was a human side that I could relate to. But there are other factors involved which have to do with the city attorney's office and the behind the scenes on the Sunshine Task Force that I believe is responsible for most of my misgivings about this. And these are serious misgivings. And I have not been a serial complainant. I've had three complaints in 2017 and 4 complaints in 2018. That's it. And all
Your time is up, sir.
my complaints are surrounded regarding those complaints. And that's it. Thank you.
Okay, members. I want to kind of get.
Do we have more public comment?
I don't think so. Any more public comment? No. Okay, public comment is closed. Okay, so for the rest of the items on the agenda, number 8 is fairly important. We've been working on it for a couple of meetings. I think it could wait one more meeting, and because all of you are new, I think I think it's worthwhile to give you folks a month to read through it, see what we're suggesting and recommending here. It's a big revamp of our complaint form, intake form, to try and help give us as much information up front as possible to reduce the amount of possible misunderstandings about the merits of what a complainant might be bringing forward, and maybe help the respondent understand better what they were being asked to do in as far as the request. At the same time, providing the task force with a clarity as to exactly what's going on. So review it, read it through. We'll bring it back on next month's meeting, and then we'll see about if we can take a vote on it, agree on it, take any vote. If you have any suggestions for it, I would suggest you direct them to the complaint committee. The chair, Schmidt, is the chair. You just submit whatever your suggestions are to through Cheryl to Chair Schmidt, and then at the complaint committee they can put it on the agenda and have a little discussion about those particular items. And I'll leave it up to Member Schmidt how he wants to manage those. Or you can just wait until the next task force meeting, and we could do it there. We really would like to get it approved at the next task force meeting, but it's okay. If you have it, you have something to bring up at the task force meeting, we'll deal with it there and see if we can muscle through getting it approved, unless it's something really controversial. Does that sound okay for everyone? Okay. I'll open it up for public comment on that. I hope there isn't any, but I'll open up for public comment. And likewise for the public, if you have suggestions, please send them into the administrator. The administrator will forward them to Chair Schmidt, and that way we'll have them on the record. Public comment on this item.
What is public comment? Is this on item 8?
Item 8.
Are you asking to put it over to the next month?
I'm not asking
about the content.
Yes, I am moving it to the next month.
Okay. Sure. I'm ready when when you are, and I don't know if anybody else is speaking.
Is there background noise going on there? Sounded like a window was open.
Okay, is there any public comment, please?
Yes. Just real quickly, this is Denta Tedessa. May I just make one statement? Just a quick.
Yes, go.
The orders of determination that you have listed, when you go online and you look at the orders of determination, say for 2018, all the orders of determination have the number of the file number, the name, and what violation or no violation. But the thing is that they are spaced in a way that the previous complaint file number is under the one beneath it, making it seem like it is actually attached to it when it's not, and it's attached to the one above it. I don't know how you could fix that, but just to give that to your attention. And there's also, I believe, issues with spelling of names. So when say if I list the city attorney's office and I place and I place a particular spelling of the name, that is then changed. So we can just double check on the names and fix the order of determinations the way that it's formatted would be helpful.
Okay.
All right.
Noted.
Mr.
Next speaker.
Warfield?
I'm waiting to be called on, or what's.
I did call on you, sir. Are you ready?
I'm ready.
Go ahead, sir.
This is Peter Warfield again, Executive Director of Library Users Association. You can be reached at libraryusers2004@yahoo.com. Also by mail, P.O. Box 170544, San Francisco, California 94117. At 10:30 at night, I think it's not unreasonable, as the chair suggests, to put this over with respect to the complaint procedures. This has been something that has been rolling over and over again for months and even years. But regardless of the history of it, the fact is it's crucial to how you operate and how you work and how well you work for the public. From what I have seen, with limited opportunity to study it, it looks as though you have gotten something that does, in essence, what I have been asking for some time. And that is for there to be a plain English version of what folks can expect from open government. James Chafee, your task force's first vice president and second president, created a basic, simple Bill of Rights for the public that just said in plain English in a single page some basic things that people can expect from their government as far as what, without having to read 47 pages or whatever it is of the Sunshine Ordinance, including vast stretches that probably aren't relevant to ordinary folks getting information. That's something you urgently need, and this looks like a piece of that. However, I'm very concerned that in your efforts to presumably make a good complaint procedure, or maybe a streamlined one, you're going to bog down folks in endless kinds of questions, multiple choice things. I'm concerned that it might become a barrier to access, a barrier to filing complaints. I believe that the original concept was very simple. A person can file a complaint in any plain English way that they want, and maybe even in other languages. And there's minimal burden on them, at least at the outset.
30 seconds.
Minimal burden at the outset would mean also people could file timely complaints and gather information and so on as they think is necessary, or as they are having time, especially since this isn't happening. The hearing isn't going to happen anytime soon. You need certainly to consider what you can do to streamline things, including the excessively voluminous files and the excessively demanding at times demand for information from the complainant.
Your time is up,
And
sir.
a 45-day period for a result.
Thank you.
is urgently
Thank you,
needed.
Mr. Warfield.
Thank you.
Okay, any other public comment? Okay, seeing none. Members, I would urge you to either listen or read the minutes from the last month's meeting, regular meeting on this item. There was a lot of discussion that was very rich that might help you also. At this time, I will just say, please, you can review the administrator's report on your own. I think at this time, I would like to entertain a motion to adjourn.
So moved.
I'll second.
Who moved?
By Member Highland, second by Vice Chair Yankee. All those in favor say aye.
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 Opposed? Opposed? We are adjourned.
We have
10:31.
10:31, 10:32.
Thank you all.
Thanks, everyone. It was nice meeting you.
And think about your
Welcome, everyone.
committees.
Welcome, everybody.
What do you think, Dean? That was a nice welcome, huh, to all the newbies?
Our first meeting was 7 hours, so